All right, ladies and gentlemen, good morning and welcome. This is Judge Tim Schutz. I'm appearing from Division 9 of the El Paso County District Court. Court is prepared today to address the matter of People versus Becker. In just a minute, I'm going to go over some of the rules of the proceedings. I want to make sure, however, first that I have all panelists, scorers present. I see that I have Mr. Straight and Ms. Bruner and Mr. Forrester's here as well. So that is the entire team of panelists. I'm not sure if we have a host that is monitoring the situation, but if we have a host, can you confirm that we have all students present who are supposed to be present at this point as well? All right, I'm not hearing anything from any host. Let me ask it this way. First, on behalf of the people, team number 6, can I get an entry of appearance and commit a confirmation that the people are ready to proceed to trial?
Your Honor, we have an attorney who is having trouble connecting right now to the Zoom call. I thought that he was in the call. It turns out that he's having issues connecting right now.
Ms. Inks, are you the host?
No, I'm lead attorney for Team 6.
All right, thank you. We'll hold off for a couple of minutes to see if we can have the attorney participating. While we await the arrival, let me ask Team 2, do I have a spokesperson for Team 2, and is Team 2 present completely?
Yes, Your Honor. Everyone a part of Team 2 is here.
All right, Team 2 ready to proceed to trial?
Yes, Your Honor.
And that was Ms. Hunter?
Yes, Your Honor.
All right. Any preliminary matters before I go over ground rules for the proceedings?
Yes, Your Honor.
Ms. Inks?
On behalf of both teams, let the record reflect that teams have exchanged trial rosters and case materials.
Objection, we actually have not exchanged rosters or case materials yet, so I propose that we do that now.
All right. And how are you proposing to make that exchange?
We will enter our rosters into the Zoom chat, which is what's my next preliminary matter. All
right. And Ms. Hartman, is that acceptable to the defense as well?
Yes, Your Honor.
And you'll be following the same procedure. So your respective rosters will appear in the chat function?
Yes, Your Honor.
For those of you who may not be as familiar with Zoom, again, there's a taskbar button on the bottom, should be underneath all the pictures, and there's a box called chat. If you click on that, just one click on that, and you will then have chat on the right side of the feature, and we have a trial roster there that has been published by the defense. I can see that. Looks like it's in PDF format. The other thing, don't worry too much if you're not able to access that, if you're not able to readily pull it up. As you can see, each team member has their name set forth down on the bottom of the box, and we can use that as the trial progresses to know who is speaking to us. I don't yet see a roster from the people. Ms. Inks, are you in the process of filing that?
Yes, Your Honor.
All right. I'll cover a couple of other preliminary matters. Let me first address the pandemic. As folks know, we have been living in a pandemic now condition for the better part of a year. That has affected courthouse operations. Right now, we are in very restricted conditions within the courthouse. This is a Saturday that this competition is occurring, but even if it was on a weekday, we are on quite restricted proceedings. And so I am in an empty courtroom as opposed to the past 20 years or so that I've presided over these kinds of competitions where we have a number of family members typically present. But we have Zoom, so people are able to see and hear one another. This is the means by which we have public proceedings during the course of the pandemic. So we will be proceeding with the trial of People versus Becker here momentarily using the WebEx platform as our vehicle to have this public trial. I think I have a preliminary commitment that we have everybody present except for one attorney. If that attorney arrives, would you please let me know, Ms. Inks, And then secondly, you were in the midst of any preliminary matters. Was there anything else that you wanted to address?
Yes, Your Honor. Your Honor, we request the court's preference on redirects and recrosses.
So absent extraordinary circumstances, the court will not permit redirect or recross.
We request the court's preference on the Zoom naming conventions.
I don't have a defined preference. It looks to me like what I have is a D for defense /2. I'm not sure, that's team 2, I guess, and then a name, which is adequate for me. Let me take a for instance, Ms. Mauer. I can see that your name or your moniker has D/2, and then the name Haley Mauer, and then there is a BLA. So have you just given us your first and last real name, and then what follows is the character that you're playing?
Yes, Your Honor.
All right. So I don't know how everybody else's Zoom is working, but I can't see that last part. But I'll try and make sure that we all understand, as each witness is called, which witness is going to be testifying, and then also who the attorneys are. As we look around the Zoom room, judging panelists, do you see any reason why anybody would question your ability to be fair and impartial in presiding as a scoring judge on this trial? I will say I do not see any conflict or any circumstance that would create an appearance of impropriety for me to preside. You don't have to affirmatively tell me anything unless you have a problem, scoring panelists. So I'm going to take your silence as acquiescence that you're able to go forward without conflict. Okay. A reminder, counsel and witnesses, no recesses will be allowed during the course of the proceedings. We're going to go beginning to end, just completely through. If there's some kind of true medical type emergency or those kinds of things, let me know and I'll address that if it arises. Remember that any disputes concerning the competition have to be raised during the course of the competition. So if you have any disagreements, they need to be brought to my attention before we wrap things up. Reminder that, of course, that you do have time requirements. I presume I have scorekeepers. Talk to me about how that usually works. Usually they're in the jury box holding up a sign with a number of minutes remaining. Do each of you have an assigned scorekeeper that will be providing that same function so I can see the time in real time and the other panelists can as well?
Yes, Your Honor. Our timekeepers will leave our time remaining in the chat.
All right. Oh, it'll be in the chat feature? So there'll be a flash to 5 minutes remaining or 3 minutes remaining, that kind of thing? All right. So, counsel, are you then keeping your chat open as you are progressing so that you'll be able to see that?
No, Your Honor. When we do get a chat notification, there's like a small bubble that pops up. So like if it's just a number, then we'll be able to see it without even having the chat function open.
All right. And for scoring panelists, your choice on how you handle that. You can leave your chat open. It condenses the boxes a little bit because it's taken up a portion of your screen. But you're welcome to leave that open or the bubble will appear. My experience is that bubble's up not very long. So just however you view that in terms of what's most useful to you to know that we are at time limits if we are at time limits. I'm going to swear in everybody here in group fashion here in just a minute. We'll start by swearing in team members and witnesses and then scoring panelists. We typically swear in gallery members, but any reason why that's necessary, counsel, given the format that we have? Are you still swearing in gallery members? I hear crickets. Ms. Inks, is this your first round or have you had a second? Is this your second round?
This is our second round. Our presiding judge last time still did the process of swearing everyone in. Including gallery members? I believe so, yes.
Okay. Anybody else have any different experience or request?
Our judge said that it was unnecessary just because there's no way to certify that, they're being sworn in because it's a live stream. So he just did the team members, scoring panelists, and the witnesses.
I think that's how I'm going to handle it rather than a formal oath where I can't see people responding to the oath, but I'll give some guidance in terms of gallery members' conduct that's embodied in the oath so that they have a sense of that. Ms. Inks, do you have your attorney coach with us?
Our attorney coach.
You said there was an attorney who was having difficult time signing in. Did he get signed in, or she?
I believe that he is getting in now and will be in the waiting room.
All right. So I'm going to move forward. We're just about to get started with the proceedings. Before we do that, on behalf of the people, Ms. Inks or whoever wishes to take the floor for the people, would you give us an introduction of your roster? Just give us the names of the students.
Yes, Your Honor. Your Honor, opposing counsel and members of the jury, my name is Jaden Inks, and I will be delivering the cross-examination of Blake Van Owen, the direct examination of Alex Fuentes, as well as delivering the opening statement.
Thank you. Will you introduce your next team member, and I'll have that particular attorney introduce themselves and give us the same information.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Will Damon, and I will be delivering the direct examination of Jordan Markowitz, the cross-examination of Avery Becker, as well as the closing argument.
Thank you. Welcome, Mr. Damon. And next from the people.
Your Honor, our attorney is in the waiting room now. He is just waiting to be admitted.
Thank you. Next attorney from the people or participant from the people wish to introduce themselves?
Your Honor, if we may allow our witnesses to introduce themselves at this time.
Sure.
Your Honor, opposing counsel and members of the jury, my name is V. Wing, and I am Jordan Markowitz.
Your Honor.
And Ms. V, we cannot, yours is flipped. I have your stage name first, so I don't see your last name. Will you say it for me again and spell it?
Wing, N-G-U-Y-E-N.
And it's pronounced Win.
Yes.
Thank you. Next, attorney member for the people.
Your Honor, opposing counsel and members of the jury, my name is Jet Fisher and I am Kyle Kuzak.
Thank you. Welcome, Mr. Fisher. And on anybody else on behalf of the prosecution that we've not heard from yet?
Your Honor, opposing counsel and members of the jury, my name is Christian Murray and I am Alex Fuentes.
All right, same thing for you, Ms. Christian. I can't see your last name, so could you say it for me again and spell it?
Murray, M-U-R-R-Y.
Welcome, Ms. Murray. Anybody else from appearing with the prosecution?
Yes, Your Honor. My name is Brendan Maher. I will be delivering the direct examination of Kyle Kuzak and the cross-examination of Taylor Perkins today.
All right. Welcome, Mr. Maher. I think that's the completion of the six-person roster. We'll turn to the defense now. Whoever wishes to take the floor first for the defense, you're welcome.
Yes, Your Honor. Your Honor, members of the jury, opposing counsel, my name is Katie Hunter. I will be directing Blake Van Owen and crossing Alex Fuentes. I will also be delivering the opening statement.
All right. Next, on behalf of the defense.
Your Honor, members of the jury and opposing counsel, my name is Ginger Hartman. I will be giving the direct examination of Avery Becker, and I will also be cross-examining Markowitz.
Thank you. Next, on behalf of the defense.
Your Honor, members of the jury and opposing counsel, my name is Nicholas DeSalvo. I will be direct delivering the direct examination of Taylor Perkins, cross-examining Kyle Kuzak, and I will also be delivering our closing argument. And Your Honor, at this time, our witnesses would like to introduce themselves.
Your Honor,
You may.
members of the jury and opposing counsel, my name is Crystal Caruana, and I am Avery Becker.
Welcome, Ms. Caruana.
Your
Next, on behalf of the defense.
Your Honor, members of the jury and opposing counsel, my name is Chibuka Onwuka, and I am Taylor Perkins.
Mr. Onwuka, A-N-W-U-K-A?
Onwuka.
Thank you. Have it. Welcome, Mr. Onwuka. Last, on behalf of the defense.
Your Honor, opposing counsel and members of the jury, I am Haley Maurer and I am Blake Van Owen.
I lost you for just a second. You're fine on your video. I just was still getting down that last name. So is it Ms. Maurer?
Yes, Your Honor.
All right. Welcome, Ms. Maurer. All right. We'll now administer oaths. Team members, please raise your right hands. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
Yes, Your Honor.
Your Honor.
Thank you. And now we'll separately swear witnesses. Witnesses, if you'd raise your right hands, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Gallery members, I'm not going to swear you in, but the typical oath that we give to gallery members is just a reminder to teachers, coaches, family members, and friends, everybody who's in attendance, to be sure that you represent yourselves as positive role models as it relates to this mock trial competition, and to behave in a manner that exemplifies ethical and professional sportsmanship during and after the mock trial round. So just a reminder that you are the people that these young adults are modeling. And just bear that in mind as we deal with any disagreements or issues surrounding the competition. Scoring panelists, I'll swear you in as well if you'd raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and the rules of the mock trial competition?
Yes, Your Honor.
Thank you. All right, one adjustment here, and then we're going to proceed to opening statements, first from the people and then from the defense. A reminder to the scoring panelists, it'll make your lives much easier if you score in real time. So as each witness is done, I'll pause a bit to allow you to get your scores on your scorecards. And then, so I'll take kind of a pregnant pause to let you complete some scoring, and then we'll come back to the next witness as the case may be. One other adjustment, I am looking in chat in real time, and I think this is from the Southern Colorado competition committee or representative. And in chat it says, Judge, allow brief redirect examination and very brief recross. So I will tell you that what I'm hearing from that is that they want me to afford you at least some opportunity to present redirect or recross. I'll follow that rule, but know your audience. And what I mean by that is I've already told you that I'm disinclined to permit any extended redirect or recross. So absent unusual circumstances, the court generally does not permit redirect or recross. But I will consider individual argument if you think there's reason to allow you to conduct a redirect recross in a particular instance. I'll want you to give me some justification for it. All right. With that, we will proceed to opening statements. First, from the people. I guess a reminder, you all obviously here are well trained on these issues beforehand. I can see that those people who are not going to be giving opening statements have basically turned their cameras off, which we appreciate, and their microphones. We will allow the opening statement to be made, and then if you are not a direct participant, just as you have already done, I would ask that you do that, which I know you already know, and that is turning your microphone and your camera off when you are not directly participating. Sorry to keep you waiting, Ms. Inks. The floor is yours.
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and my co-counsel and I are here today on behalf of the people of the state of Colorado. Revenge is a powerful motivator. This case is about a tragedy. On March 6, 2020, a beloved coach and well-respected attorney, Mackenzie Brackman, was found dead in his home at 444 South Flower Street. Avery Becker committed this crime. On March 6th of 2020, Avery Becker entered Mackenzie Brackman's home with the intent of causing destruction. Upon entry, she was surprised to find that the house was not empty. This resulted in a physical struggle between Mackenzie Brackman and Avery Becker. It is our assertion that Ms. Becker took a knife, stabbed Mackenzie Brackman in the upper left back, nicking his aorta and causing him to bleed to death. After being left dead in the entrance to his home, Avery Becker then fled the scene. The relationship between Ms. Becker and Mackenzie Brackman has spanned the 4 years that she has spent time on the same mock trial team that Coach Brackman coached. The relationship between Avery Becker and Mr. Brackman has had bad blood since the start. Mr. Brackman would often criticize Avery on her techniques as they put her team in a constant difficult position. Avery often demonstrated lazy work ethic, would show up to practices late, and would come unprepared for competitions. Brackman and Avery constantly disagreed upon this, and it caused Brackman to be hard on Avery. Brackman encouraged Avery to work harder and called her out on the persistent harmful antics that let her team down. Confrontation was not something that Ms. Becker liked, and this led to a strong disdain for her coach. This disdain grew further as a result of not being able to meet Coach Brackman's expectations. Avery was then demoted to a lower team. Ms. Becker manipulated her way back up to a higher team by getting her friend Taylor Perkins to quit the team, causing Mr. Brackman to have to reinstate her back onto A team. After the regional competition, Mr. Brackman confronted Avery about letting down her team. She again took this personally as an attack against her. Avery took this feedback terribly, leading to a reckless decision. After practice, she stormed out of the school and in the parking lot wrote with a permanent marker on the hood of her coach's car, "Worst Attorney Award." This was the final straw, the boiling point. Coach Brackman permanently kicked Avery off of the team. And Avery used this opportunity to seek revenge once more, to commit her crime. Today, the prosecution will put forward 3 witnesses: Detective Markowitz, Kyle Kuzak, and Alex Cifuentes. Detective Markowitz will testify to how Mackenzie Brackman was killed, with his experience at the Denver Police Department in homicide investigation from his years of being a homicide detective. He will walk you through the events that transpired on March 6th, leading to Mackenzie Brackman's tragic death. Next, Kyle Kuzak will testify on behalf of his years in crime scene reconstruction with the Colorado Bureau of Investigation. This evidence that he will provide will establish Avery Becker's revenge, leading to the killing of Mackenzie Brackman. Finally, Alex Cifuentes will testify to her personal knowledge of the defendant from being on the team with her. Taylor Perkins, she was a team member on the same mock trial team as Coach Mackenzie Brackman and defense witnesses Taylor Perkins and Avery Becker. Alex Cifuentes will help explain what motivated Avery Becker in committing her crime. Avery Becker is charged with first-degree murder and second-degree burglary of a dwelling. It is not our duty as the prosecution to prove to you the intent of Ms. Becker in killing Mr. Brackman. Instead, we will prove to you that Ms. Becker broke into Mackenzie Brackman's home with the intent of criminal mischief that led to a death, leaving Ms. Becker guilty of murder in the first degree and second-degree burglary of a dwelling. The prosecution carries the burden of proof, a burden that they will not be able to meet. At the conclusion of this trial, we, the prosecution, will ask you, the jury, to return a verdict of guilty to Ms. Becker because the revenge that Avery sought was a powerful motivator. Thank you.
Thank you, Ms. Inks. We'll turn now to defense opening statement. Does the defense desire an opening statement?
Yes, Your Honor.
Ms. Hunter, you have the floor.
Thank you. Your Honor, members of the jury, opposing counsel. The truth, the whole truth, and nothing but the truth is what the defense is here to deliver today. Now, the truth is there were other murder suspects in this case. The truth is Avery Becker has an alibi. The truth is Avery Becker is innocent and stands before you today pleading not guilty to murder in the first degree and second degree burglary of a dwelling. Avery Becker, a senior at Colorado High School, was on the mock trial team with Alex Cifuentes and Taylor Perkins. Avery and Coach Brackman admittedly had a rocky relationship. Avery, although naturally talented as an attorney, often didn't prepare the way Mr. Brackman wanted her to. In early 2020, after a mock trial regional competition, Mr. Brackman criticized Avery for her lack of preparation. Avery, frustrated with Mr. Brackman, made one of the worst mistakes of her life. With what she believed was a dry erase marker, she wrote on Mr. Brackman's 1986 Porsche Worst Attorney Award. Avery later learned that it was actually a permanent marker. Mr. Brackman, discovering this, kicked Avery off the team. The next day, Avery made multiple attempts at reconciliation, but never succeeded in apologizing because of his tragic death, in person, that is. After Avery tried to apologize, her and her close friend Taylor Perkins went to the Fry Shack. The Fry Shack is a local restaurant a lot of kids on mock trial like to go to. On March 5th, this was the day before the murder, they were playing games on their phones at the Fry Shack, and Avery even let Alex Cifuentes play a game on her phone, even though they aren't the best of friends. The next morning, March 6th, the day of the murder, Avery discovered her phone was missing. The last place she remembered seeing it was at the Fry Shack. You are going to hear a lot about cell phones and cell phone towers in the trial today, supposedly proving Avery was at Mr. Brackman's house. However, Avery didn't have her phone, and if she didn't, who did? There are lots of unanswered questions in this case, and we hope today that those questions prove there is reasonable doubt. There are a lot of truths within this case as well, but we also hope today that we can help you understand the whole truth, not only the selected evidence provided by the prosecution. The truth is there were suspects that were not pursued. The truth is there is evidence that is missing or corrupted. The truth is the police performed an incomplete investigation. Now, although there was some high school drama between Avery and Mr. Brackman, this drama did not rise to the level of murder Avery is being charged with. Avery and Taylor were with each other on March 6th, the day of the murder, the entire day looking for Avery's lost phone. After spending time looking for that lost phone, Avery Becker, a high school student, was suddenly a suspect in a murder case. But you will hear from Avery herself today. She will offer her firsthand account of what actually occurred on March 6th. Next, we will have Taylor Perkins, a good friend of Avery, share a second perspective, and that will confirm Avery's innocence. Lastly, we will have Blake Van Owen, an expert in police practices, and she will talk about what the police may have missed in this case. I would like to remind the jury of jury instruction 2. Every person charged with a crime is presumed innocent. Avery Becker is presumed innocent. This presumption of innocence remains throughout the entire trial. The burden of proof is upon the prosecution today to prove beyond a reasonable doubt that Avery committed this crime. Like they said in their opening, they simply cannot do this. The defense will prove that there is reasonable doubt. The defense will offer the facts within this case. The defense is here to uncover the truth, the whole truth, and nothing but the truth. And after you see the lack of evidence in this case, you will find that the only just verdict that can be given is that of not guilty. Thank you.
All right. Thank you for your presentation, Ms. Hunter. We will turn now to the presentation of evidence in the case. People may call their first witness. I would like the two attorneys who will be handling direct and cross of the witness and the witness to state their names for purposes of our scoring.
Yes, Your Honor. The people would like to call Detective Jordan Markowitz to the stand.
And that was Mr. Dahman?
Yes, Your Honor.
Bear with me. And who will be handling cross-examination for the defense?
That will be me, Your Honor, Ginger Hartman.
Welcome, Ms. Hartman. And our witness will be?
My name's V. Wing, Your Honor.
Welcome, Ms. Wynn. We will begin with direct examination.
Yes, Your Honor. Good morning. Please state and spell your last name for the record.
Jordan Markowitz, Markowitz.
And what is your occupation?
I am a homicide detective with the Denver Police Department.
How long have you worked with the Denver Police Department?
I've been with DPD for 13 years and 7 years as a homicide detective now.
What sort of certifications do you have?
I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. It instructs you on how to obtain and interpret cell phone data, as well as cellular data and cell tower data.
How often do you use this certification?
I've used it on a daily basis. In fact, I've used it in over 50 cases now.
Your Honor, at this time, pursuant to Rule 702, I move to enter Detective Jordan Markowitz as an expert in homicide investigation with an emphasis on cell phone technology.
Any objection to the proffer, Ms. Hartman?
Your Honor, a brief audier, if I may.
You may.
You are currently a homicide detective, is that correct?
Yes, I am.
And you've been with the Denver Police Department for around 13 years?
Yes, that's right.
But only a detective for 7 of those years?
Yes.
And you have specialized training in cell phones?
I do.
Is it correct that you have a cell phone technology and forensic data recovery certification?
That's right.
But to get that certification, you only had to complete a mere 3-day training course?
Yes, but it was a very thorough training that went through an intensive course.
Okay, Your Honor, I have no objections to this witness being entered as an expert as long as they stay strictly in the bounds that they're being entered in.
Thank you. Ladies and gentlemen, normally, of course, witnesses may only testify to facts. The exception to that is if a person, by virtue of their training, experience, and/or knowledge, have special expertise in a particular area, they may give opinion testimony as well as factual testimony. Ms. Wynn's been appropriately qualified, and she will be allowed to give opinion testimony in the field of homicide investigations. Mr. Dahman?
Yes, Your Honor. Mrs. Markowitz, let me take you back to the events on March 6th of 2020. Where were you on that day?
On March 6th, we got a report from a passerby that saw a person possibly passed out on 444 South Flower Street. We were then called in to investigate the scene.
And upon arrival to 444 South Flower Street, what did you see?
Officer and I arrived to find the victim, Mackenzie Brockman, deceased inside the front door. Additionally, a large knife was found near Mr. Brockman's body.
Would you recognize some photos of the crime scene if I showed them to you today?
Yes, definitely.
Your Honor, at this time I ask permission to show the witness what has been marked as Exhibits 1 and 5.
Any objection?
No, Your Honor.
1 and 5 are admitted and they may be published. How do you wish to publish them, counsel?
Your Honor, we were going to screen share them for the purpose for the witness and the jury to look at the exhibit.
All right.
And Detective, what are these photos?
These are the photos of the victim, Mackenzie Brockman, as well as the large knife I found near his body.
Are these fair and accurate representations of the Mackenzie Brockman's body and the knife you found?
Yes, they're accurate.
Your Honor, at this time I move to enter exhibits 1 and 5 into evidence.
I thought 1 and 5 were previously offered. Were you just asking to be able to publish them?
I was asking for permission to show the witness what has been marked as those exhibits, Your Honor.
All right, is there any objection to 1 and 5?
Your Honor, I have no objections.
So they are admitted. Counsel, just FYI going forward, I don't want you to publish the exhibits until they are admitted into evidence. So if you need to lay a foundation by showing them to the witness, I want you to do that in a fashion, if you can, where only the witness can see it rather than the jury, because the purpose of laying the foundation obviously is to make a determination that it's admissible. But if they're already seeing it before I've ruled on admissibility, then we have problems with potentially exposure to evidence that the court may determine is not admissible. Am I clear in terms of what the court's preference is?
Your Honor, if I may direct your attention to the rules of the competition 7.4, with the format they were instructed to do is to screen share, and the jury is supposed to disregard the exhibit until it has been moved to publish, just for that way you, Your Honor, can look at the exhibit and rule on admissibility, as well as the witness and opposing counsel to look at the exhibits. However, until it has been motioned to publish, we are not allowed to, the jury is supposed to disregard the exhibit as pursuant to.
All right. Is the defense in agreement with the applicability of Rule 7.4?
Yes, Your Honor.
Okay, we'll follow that procedure then for purposes of this competition. Just a reminder to those who are in attendance that normally the fact finders, the panelists in this case, do not see evidence until it's actually admitted into evidence, because the court has to make a determination of its admissibility before it gets published. We have to compromise that rule in the circumstances that are presented in the pandemic and the moot court competition. So we'll follow the rule as articulated and agreed upon by counsel. You may continue, Mr. Dunn.
Your Honor, motion to publish at this time.
And that's granted.
Detective, can you describe how you found Mackenzie Brockman?
Yes, Mackenzie Brockman was face down in a large pool of blood. His shirt was soaked with blood around the upper left back and shoulder area right here. A large knife was also found near his body, as I previously stated. There was blood splattered on the walls and ceilings as well.
After examining the body, what did you do?
Afterwards, I noticed a Ring doorbell camera, which led me around the back and the side gate, which was unlatched and open. I also noticed that the back door was open and unlocked as well.
What did you do after you noticed the back door was unlocked?
I then entered through the back door into the kitchen to find the residence in slight disarray. There was a broken plate on the floor, a knife drawer open, and earth drops on the floor.
Would you recognize photos of the knife drawer and the broken plate if I showed them to you today?
I would.
Your Honor, permission to show the witness what has been marked as exhibits 7 and 9 at this time.
Any objection, Ms. Hartman?
No objections, Your Honor.
Permission granted.
Detective, what are these?
These are the photos of the broken plate and knife drawer that I discovered.
Are these fair and accurate representations of what you saw on March 6th?
They are accurate.
Your Honor, motion to enter exhibits 7 and 9 into evidence.
Any objection to either 7 or 9, Ms. Hartman?
No, Your Honor.
7 and 9 are admitted and they may be published.
Motion to publish, Your Honor.
I just granted that.
Thank you. Detective, after examining the kitchen, what did you do?
Afterward, I accessed Mr. Brockman's phone, which gave me access to his Ring security camera account. On the account, I found 4 videos of a hooded and masked individual that entered the residence.
After searching Mackenzie Brockman's phone, what did you do?
I noticed that he was a part of a thing called mock trial. So I was later contacted by a student named Alex Fuentes, who gave me screenshots of a text conversation between her and another student. In addition to that, after searching the residence, I noticed nothing of value was missing.
Would you recognize the screenshots if I showed them to you today?
Yes.
Your Honor, permission to show the witness what has been marked as Exhibit 14.
Any objection, Ms. Hartman?
No, Your Honor.
Permission granted.
Detective, what are these?
These are the screenshots I received from Alex Fuentes between her and other mock trial student, Avery Becker.
Are these fair and accurate representations of those screenshots?
Yes, definitely, they're accurate.
Your Honor, I move to enter Exhibit 14 into evidence.
Any objection to Exhibit 14?
Your Honor, I object to hearsay.
All right. Any response to the hearsay objection, Mr. Damon?
Your Honor, pursuant to Rule 801D2, these are statements made by the party opponent, Avery Becker, and therefore definitionally not hearsay.
Any reply?
Your Honor, these statements are made not even through a physical phone or a download of the copy, and it's a statement made through text message of Avery, so it's not a statement that was verbally heard.
All right.
If I may.
Briefly.
Your Honor, hearsay is here can incorporate any verbal or written statement, and still this is 801D2 of a statement by a party opponent.
Court concludes that this is a statement by a party opponent. It's excluded from the definition under 801D2, and there's no distinction between verbal statements or written statements for purposes of defining hearsay. So the objection is overruled. The exhibit is admitted, and it may be published. This is 14.
Thank you. Detective, after receiving these screenshots, what did you do?
I then tried contacting Avery Becker, but unfortunately her lawyer blocked me, which prompted me to get a search warrant to search Miss Becker's phone.
What did you find with Miss Becker's phone?
In actuality, I never found Miss Becker's phone. Supposedly that I learned that Miss Becker's phone had been lost since March 5th, which then afterwards I got a court order to search Miss Becker's cell provider records instead.
What did you find with the cell provider records?
I was then able to access cell detail records, or CDRs for short.
And what are cell detail records?
Well, CDRs are records that service provider collects when a phone connects to a cell tower. So if you looked at nearby towers, you can actually pinpoint where a phone is. So while those CDRs don't provide what is said in these communications to the tower, it can detail whether a call or text message was sent out or received and how long a call lasted. But most importantly, it identifies which cell tower that phone communicated with.
And how do cell phones interact with cell towers?
Now, that's a complicated algorithm that determines which cell connects with a cell tower. So a phone will most of the time connect to the nearest tower. However, it can connect to the tower if the nearest one is full and overloaded, but that's highly unlikely.
What cell detail records did you find concerning Miss Becker's phone?
Well, on March 6th, Miss Avery Becker's phone received communication that went through cell tower 1227-3, tower 1191-1, in addition to cell tower 1197-1.
Do you want to go more into what that data means?
Yes, I actually created this diagram that details the CDRs.
Would you recognize that diagram if I showed it to you today?
Yes, definitely.
Your Honor, permission to show the witness what has been marked as Exhibit 15.
Any objection, Ms. Hartman?
No, Your Honor.
Permission given.
Detective, what is this?
This is the diagram I created that details all the CDRs that Ms. Becker's phone received on March 6th after Brockman's homicide.
Is this a fair and accurate representation of your diagram?
Yes, it's accurate.
Your Honor, I move to enter Exhibit 15 into evidence.
Any objection to 15?
No, Your Honor.
15 is admitted and may be published.
Your Honor, at this time, I ask that my witness be allowed to annotate on the document to explain her expert opinion with her diagram.
All right. Any objection to that, Ms. Hartman?
No, Your Honor.
We'll permit that.
Detective, can you elaborate on what those cell detail records mean?
Yes. Can you give me one moment, Your Honor, as I pull up the annotations tool on my side?
Of course.
So, March 6th, around 12:47 p.m., Avery Becker's phone received a text message in cell tower 1227-3, which I have circled. And then in addition to that, the phone received another text message at 12:55 p.m. on tower 1191-1, 17-1, as I circled right here.
And what does that signify?
So this would correspond to Miss Becker's most ideal route from her home along Rock Creek Parkway, as I am drawing to Mr. Brockman's residence.
Did you find any other cell detail records?
Yes, after which at 13:05 or 1:05 p.m., a call was received at Tower 1197-1, and then a additional call was then received at 1:06 p.m. And then a final text message was sent to Ms. Becker's phone at 1:17 p.m. All three of these communications went through cell tower 1191-1. I meant 1197-1. My apologies.
And in your expert opinion, what does this all signify or indicate?
So this will respond to Ms. Becker's route from her house to Mr. Mackenzie's Brockman. So as I stated, so according to this data, on March 6th, the day of Mr. Brockman's homicide, between 12:45 p.m. and 12:50 p.m., Avery Becker was most likely at home. Then she left to drive to Mackenzie's Brockman's house, most likely along Rock Creek Parkway. Then from 1:05 to 1:17 p.m., Avery Becker was at Mr. Brockman's house.
Your Honor, at this time, I move to enter the demonstrative as 15B into evidence.
Any objection to 15E being offered for demonstrative purposes?
No, Your Honor.
So 15E will be admitted for demonstrative purposes, and it may be published.
Detective, do you have an expert opinion on who killed Mackenzie Brockman?
I definitely do.
And before you give us that opinion, what factors did you rely upon?
So I relied on all the evidence I thoroughly gathered in this case, but I did rely heavily on the cell detail records and the text messages.
And are these factors reasonably relied upon?
Yes, they are.
And Detective, what is that opinion?
It is absolutely clear that Avery Becker broke into Mackenzie Brockman's home to burglarize and vandalize the property. However, Mr. Brockman confronted Miss Becker, so then the both ended up in a scuffle that resulted in Avery Becker fatally stabbing Mr. Brockman.
Thank you, Your Honor. No further questions at this time.
Thank you, Mr. Damon. Cross-examination, Ms. Hartman?
Yes, Your Honor. Good morning, Detective Markowitz.
Yes, good morning.
So you were assigned to investigate the death of Mackenzie Brockman?
Yes, that's correct.
And you were called to the scene of the crime?
Yes, on March 6th at 14:20 or 2:20 p.m.
And you observed the crime scene yourself?
I did.
And one thing that you observed were blood drops on the floor?
Yes, that's right.
And are there pictures of these blood drops?
Unfortunately, the pictures we took were corrupted and we weren't able to recover them.
Were any backups made?
Unfortunately not.
And the same thing happened to images of the blood splatter at this crime scene?
Yes, they were part of the same file that got corrupted, unfortunately.
Now to the victim. You knew Mackenzie Brockman on a personal level before you were on a professional level.
Relevance?
Any response to the objection, Ms. Hartman?
Your Honor, I'm sorry. I actually didn't hear the objection.
It was an objection on the grounds of relevance.
Oh, okay. Your Honor, this is relevant due to the fact that any prior connection between the witness and the victim of this crime could have an influence on how the victim sees this case.
Any brief response?
Your Honor, I see how a personal connection between the deceased has anything to do with whether Avery Becker did or did not commit first-degree murder or second-degree burglary.
The objection is overruled. The court concludes it does go to the issue of credibility. Ms. Hartman, you may continue and you may re-ask the question.
All right. So you knew Mackenzie Brockman on a personal level before you were assigned to this case. Is that correct?
Yes, I met Mr. Brockman through various court, but that won't bias my judgment in this case that I investigated.
You were cross-examined by him in court. Is that correct?
Yes.
And you even considered these encounters with him a displeasure?
Yes, but Mr. Brockman was only doing his job.
But he attacked the poor police work of your station as well as you personally?
Yes, he did, but that was part of his job, and that unfortunately that won't ever bias my judgment into thoroughly investigating his death.
Now, you interviewed Alex Cifuentes, is that correct?
I did.
And you looked at his phone, is that correct?
I did.
You looked at his physical phone?
No, I never was able to look at his phone, as he sent me screenshots of the text conversation instead.
But that was after the interview happened.
Yes, as Mr. Cifuentes did not have his phone at the time during the interview, but people get nervous when they are interviewed by police.
Did you ask for the physical phone after the fact?
No, I just asked him to send me screenshots of the conversation instead.
Okay, now to the cell phone towers. Does a phone necessarily have to ping off the closest tower for it to connect?
Most of the time it does, but in some situation it does connect to another tower if the nearest one is full and overloaded. But like I said, that's highly unlikely in this case.
What would be an instance where the phone would connect to a further tower?
Like I previously answered your question, when the cell tower is full and overloaded.
So did Avery Becker have to be driving on that path that you drew on the map of the evidence entered? Did she have to be driving on that path for her phone to be pinging off those towers?
Yes, that's the most ideal route Miss Becker would take to Mr. Bachman's house.
But to ping off the towers, it doesn't necessarily have to be?
Yes, in some circumstances.
Your Honor, I have no further questions for this witness at this time.
Thank you, Ms. Hartman. Any redirect examination, Mr. Damon?
I don't think any is needed, Your Honor, and I ask that my witness be allowed to step down from the stand.
All right. Thank you. Detective Markowitz, we appreciate your testimony here today. You are free to step down. I'm going to pause for a minute to allow scoring by the panelists, and then we'll call our next witness on behalf of the prosecution. All right, people may call their next witness. We'll follow the same procedure. I'll want your individual name and for the witness, the person that you will be portraying. Mr. Mayor, on behalf of the people.
On behalf of the people, we call Kyle Kuzak to the stand, and I will be direct examining Kyle Kuzak, and my name is Brendan Maher.
All right, thank you. And Mr. Kushak, remind us of your name.
Jet Fisher.
All right, bear with me. And who will be handling cross-examination of Mr. Kuzak?
That would be me, Your Honor, Nicholas DeSalvo.
All right, thank you. Mr. Mayor, you may begin your examination.
Yes, Your Honor. Mr. Kuzak, please state your name and spell the last for the record.
Kyle Kuzak, that's spelled K-U-Z-A-K.
And what is your employment?
I am a Colorado Bureau of Investigation certified crime scene investigator, or if that's too much of a mouthful, CSR will suffice.
And how long have you been investigating crime scenes?
Let's see, I have 19 years of experience, with the most recent 3 being with the city of Denver.
And what does that entail?
I investigate complex crime scenes, including home invasions, burglaries and other property crimes, domestic violence, homicides, fatal accidents, and armed robberies.
And what is your mindset going into a new crime scene?
I have 2 key principles that guide my work. First, I believe that every case is going to trial, so I conducted a very thorough and a very comprehensive investigation. Second, starting from day one, I memorialized, documented, and organized all events, mind you, with a mindset of future reconstruction.
And how do you go about the actual investigation, Mr. Kuzak?
I approach all my CSR work in 5 steps. That is recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, as well as reconstruction.
And is this methodology common practice among your colleagues?
Yes, it is.
Your Honor, pursuant to Rule 702, I move to enter Kyle Kuzak in as an expert witness as an expert witness in crime scene reconstruction to render his opinion in that area.
Any objection to that proffer, Mr. DeSalvo?
Yes, Your Honor, and a brief voir dire, if I may.
You may.
Mr. Kuzak, have you submitted a CV to the court today?
No, I have not.
So there's no way of knowing where you were certified?
That is correct.
Or how long it took to receive that certification?
That is correct.
So your training and education in the field of CSR work is unknown to this court?
That is correct.
Your Honor, the defense objects to the admission of Kyle Kuzak as an expert witness in the field of crime scene reconstruction, given that his level of training and education is not clear.
Thank you. Any response to the objection, Mr. Mayor?
Yes, Your Honor. In order to have somebody in as an expert, I did lay enough foundation for, he gave testimony for 19 years of experience. And I only need to prove one thing as experience. So he has the qualifications to become an expert in this court.
All right. Court concludes that there is an adequate foundation by virtue of the witness's testimony concerning his experience that he can qualify as an expert witness in the field of crime scene reconstruction. The rule does provide that a witness may be qualified as an expert based upon either knowledge, training, or experience. And the court concludes that there is an adequate showing of experience. The other aspects of the investigator's background go to the courts, or go to the weight rather than the admissibility or qualifications for him to opine. So the court will allow him to be qualified as an expert in the scene of crime scene reconstruction. He may give opinion testimony in that regard. Counsel, just before we continue with the examination, just a brief point of clarification. I think there may have been a miscommunication previously with respect to the court's position on redirect. The court generally, and I think candidly, I think the miscommunication was mine. So just to clarify, the court does permit direct, cross, and redirect as a matter of course. The court generally does not permit recross or redirect absent unusual circumstances. So you can just take that into consideration as you go forward. Yes, Mr. Mayor, you may continue with the examination of Mr. Kuzak.
Yes, Your Honor. Mr. Kuzak, why are you here today?
I am here today to testify to my findings at the scene of the homicide of Mackenzie Brackman at 444 South Flower Street. I conducted that 5-step methodology I talked about earlier during this case.
And what kind of conclusions did you come to after completing your methodology?
After reconstructing all of the evidence, I found that the perpetrator that approached Mr. Brackman's home matched the same height and build of the defendant, initially stepping on the front porch and checking the door.
And do you believe the victim was alerted of the intruder?
Yes, I believe the victim was alerted by his Ring video security and then prepared himself.
And was there anything left near the back door?
Yes, there was some scuff marks on the floor near the sliding back door, and that was also near the kitchen.
Your Honor, may I show the witness what has been marked as Exhibit 18?
Any objection, Mr. DeSalvo?
No, Your Honor.
You may.
Mr. Kuzak, do you recognize this image?
Yes.
And what is this?
This is an image of the scuff marks near the back sliding glass door.
And is this a fair and accurate representation of those scuff marks you saw that day?
Yes, it is.
Your Honor, I move to admit Exhibit 18 into evidence. Any objection to 18?
No objections, Your Honor.
18 is admitted and it may be published.
Yes, Your Honor. Mr. Kuzak, what is your opinion on these scuff marks?
These scuff marks clearly indicated that a struggle took place in the kitchen and near the back door.
Co-counsel, you can take it down now. Did you notice anything else in the kitchen, Mr. Kuzak?
Yes, I noticed an open knife drawer as well as a knife block with one knife missing.
And is Exhibit 7 that same knife drawer?
Yes, it is.
Did anything else indicate a struggle?
Yes, there was also a broken plate on the floor 5 feet from the back door on the kitchen floor.
And is Exhibit 9 that exact same plate?
Yes, it is.
What do you believe happened next?
The perpetrator and the victim ensued in a struggle, and that led to the victim being killed by the perpetrator.
And what was around the body and the knife?
Where the body was discovered, which was near the front door, I found a cast-off blood splatter on the ceiling and wall, and this is consistent with the victim pulling the knife out himself.
And why did this homicide happen, Mr. Kuzak?
This was clearly a planned burglary gone wrong. The perpetrator chose a time when the victim would have not been home. Unfortunately, that was not the case. The two ensued in a struggle, which led to Mr. Brackman's death.
And finally, do you believe that this is the only conclusion for the events that happened that day?
Yes, the conclusions that I have expressed today are based on sufficient facts and data. They are a product of reliable principles and methods. This is the only possible conclusion for the events that occurred.
No further questions at this time, Your Honor.
Thank you, Mr. Mayor. Cross-examination, Mr. DeSalvo?
Yes, Your Honor. Mr. Kuzak, you're not a police officer, correct?
That is correct.
And you visited the scene of the homicide after other members of the crime lab had processed it?
Yes.
And you're very thorough with your work, correct?
That is correct.
You memorialize, document, and organize all evidence?
Yes.
You even use witness tracking sheets to summarize key points of information, which you also then review?
Yes.
If I were to show you the witness tracking sheet, would you recognize it?
Yes, I would.
Your Honor, permission to have what has been marked as Exhibit 17 screen shared for the court.
Any objection, Mr. Mayor?
No, Your Honor.
Permission is granted. Is somebody pulling up Exhibit 17?
They should be, Your Honor.
All right. We'll wait just another minute or so, otherwise I'm going to have you move on. If there's the person who is trying to publish it, you can take yourself off mute and let me know if there's any problem in that regard. There we have it.
Thank you. Mr. Kuzak, do you recognize this Exhibit 17?
Yes.
And what is this?
This is the witness tracking spreadsheet that I made.
And is it in the same condition as you saw it last?
That is correct.
Your Honor, I move to publish what has been marked as Exhibit 17 into evidence.
You're offering it into evidence initially?
Yes.
Any objection to Exhibit 17?
Yes, Your Honor. I object to hearsay and cumulative.
All right. Any response to the objection, Mr. DeSalvo?
Your Honor, Mr. Kuzak, who has been entered in as an expert witness, said and verified that this is the witness tracking sheet that he had filled out information on. And it's extremely important in this case as far as how information was collected in the investigation.
Tell me on the, I'm not so concerned about the cumulative objection, but on the hearsay objection, how is this not hearsay if it's going to be admitted into evidence, what's the basis for admitting it?
Well, this Mr. Kuzak would be considered a party opponent, and these are statements from a party opponent.
Your Honor, if I may, the party opponent rule only, that would mean from the opponent of the witness on stand. So I don't believe that's the case.
Court agrees. Party opponent, Mr. Kuzak's a witness, not a party opponent. Even though he's testifying for one side, that doesn't make him a party. Any other exception to the hearsay rule that you think is applicable?
Your Honor, if I had a moment to gather myself.
You may.
Your Honor, in accordance to Rule 803, 5, this would be recorded recollection that accurately reflects the witness's knowledge and the witness's knowledge of this case.
Your Honor, if I may, I don't believe co-counsel has laid enough foundation in order for this rule to apply to the document.
Any response to the lack of foundation?
Your Honor, if I may, I could lay more foundation and then attempt to.
You may, either in support of that hearsay exception or any other hearsay exception that you think is applicable.
Okay. Mr. Kuzak, so you did say you investigated the scene of the crime. And you reported evidence that you collected in a witness tracking sheet.
Yes.
And your knowledge in this case, and the conclusions in this case were formed around the information that you collected in this witness tracking sheet.
That is correct.
Your Honor, I now move to enter what has been marked as Exhibit 17 into evidence.
Any response?
Yes, Your Honor, I still object to hearsay due to the fact that this is a document being offered for the truth of the matter asserted.
Has he laid an adequate foundation for past recollection recorded? That is an exception, as you know, to the hearsay rule.
Yes, Your Honor.
All right. Then the court deems Exhibit 17 admitted pursuant to 803.5, and it may be published.
Thank you, Your Honor. There are a few names on this tracking sheet that aren't mentioned in your affidavit, correct, Mr. Kuzak?
That is correct.
And Taylor Perkins even mentions someone known as Blair Rollins.
That is correct.
But you failed to investigate a possible suspect in this crime, Blair Rollins.
That is also correct.
On the topic of suspects, Alex Cifuentes is marked as suspect number 2, correct?
Yes.
Permission to have Exhibit 17 taken away from screen share.
You may. And you have that permission going forward. You don't need to ask permission, so you can do it as you deem appropriate. And that, of course, applies to all counsel.
From the ring videos, you concluded that the individual in the video matched the general height and build of Avery Becker, correct?
Yes, it was the same height and build.
But you can't be certain of that given that the perpetrator had on a mask.
That is correct.
So it could really be anyone that size.
That is correct.
And there were no fingerprints or DNA recovered from the site other than from Mr. Brackman.
Yes.
So there's no forensic evidence to pinpoint who exactly committed this crime.
That is correct.
But you do believe there was a struggle,
Yes.
which left scuff marks.
Yes.
But Mr. Kuzak, these scuff marks can't be carbon dated. So is it possible to know when those scuff marks were created?
No.
There was a struggle, and Mr. Brackman was killed as a result of that struggle, correct?
Yes.
After they fought over the murder weapon that Mr. Brackman had introduced.
Yes.
And the loser of that struggle, that battle, was killed.
Yes.
No further questions at this time, Your Honor.
Thank you. Any redirect, Mr. Mayor?
Yes, Your Honor, very brief. Mr. Kuzak, were you ever able to locate Blair Rollins?
No, I was not.
And do you need DNA evidence to convict somebody?
No, you do not.
And was there enough signs at the crime scene to indicate a struggle?
Yes, there were the scuff marks and the broken plate.
Your Honor, no further questions at this time, and barring no recross, I ask that my witness can step down from the stand.
All right. Any recross?
No, Your Honor.
All right. Thank you. Mr. Kuzak, we appreciate your testimony here today. You are now free to step down from the witness stand by turning your microphone and your video off. Again, I'll pause just a minute to allow scorers to score that particular witness, and then we'll proceed with the people's third witness. Plaintiff, or the prosecution may call its next witness.
Your Honor, the prosecution calls Alex Cifuentes to the stand.
And that is Ms. Inks.
Yes, Your Honor.
Thank you. And who will be cross-examining?
I will, Your Honor.
Ms. Hunter? And Ms. Murray will be portraying Ms. Cifuentes.
That's correct.
Ms. Murray, am I saying your last name correctly, Ms. Cifuentes?
Yes.
All right. Ms. Inks, you have the floor.
Please state your name and spell it for the record.
Alex Cifuentes, Sifuentes.
Ms. Cifuentes, how do you know Avery Becker?
Well, Avery and I were good friends. I would even go as far to say that we were best friends. It was actually Avery during my freshman year who recommended that I join our school's mock trial team.
If I asked you to point out the defendant in the courtroom, could you?
Yes, I could.
Your Honor, I ask that Avery Becker turn on her camera to be identified. Would you please describe for me the defendant here today?
Well, as you can see, she has a darker hair color and she has freckles.
Thank you. Your Honor, let the record reflect that this witness has been identified as the defendant, Avery Becker.
It shall. Counsel, forgive a brief interjection here by the court. Panelists, I don't know if it's unique to my scoring panel, but I am looking at the first page of the scoring sheet, and running down the left-hand side, it refers to plaintiff, which in this case is the prosecution, saying plaintiff's opening, plaintiff's counsel 1, plaintiff's counsel 2, plaintiff's counsel 3, plaintiff's witness 1, plaintiff's witness 2, and then it says plaintiff's witness 1 again. I think that is a mistake in the form, and that is actually plaintiff's witness number 3, and that is Ms. Murray. So I think there's just an error in the form there. At least that's the best I understand what's going on here. So Ms. Murray should appear as the second student name for plaintiff witness number 1. All right. You may continue. I'm sorry, Ms. Inks, go ahead.
Has your relationship with Avery changed since then?
I guess you could say that's become more strained in a sense. During our last season of competition, Avery had poor behavior, constantly showed up late to practice, and never had any ounce of respect for Mr. Brackman or the rest of the team.
You mentioned that Avery didn't show Mr. Brackman the right respect. What do you mean by this?
Well, Mr. Brackman, in my opinion, was an amazing coach. He always pushed to improve the team, especially Avery. I really looked up to him.
And what effect did Avery's behavior have on the team?
Avery's behavior constantly left the team in a state of panic since she was never prepared. And this was something that Mr. Brackman constantly stressed, being properly prepared. Mr. Brackman constantly had to get on Avery to be prepared for practices and tournaments.
And how did Avery respond to Brackman's critiques?
Well, Avery hated Mr. Brackman for constantly getting on her about her work ethic. I guess you could say that they've always had bad blood.
What would you say was the boiling point of Miss Becker and Mr. Brackman's relationship?
So Avery had come into practice late like usual, and at the end of that practice, Mr. Brackman demoted her to B team.
What happened after Avery got demoted?
After being demoted, Avery then went to talk to her second best friend about quitting the team.
And after Miss Perkins quit, what happened?
Well, Mr. Brackman let Avery back on A team.
And how did this make the team feel?
I mean, like you'd expect, the whole team was upset because Avery got demoted and then just put back onto A team. And then to make matters worse, at regionals, she then won the Best Attorney Award and the Best Closing Award.
And what happened after your regional competition?
Well, after the following practice after regionals, Mr. Brackman confronted Avery, and Avery seemed really upset. And on her way out, she did something I don't think anybody would have expected.
And what did she do?
She wrote on the hood of Mr. Brackman's car in permanent marker.
And how do you know this?
Well, Avery owned up to it, and pretty much the whole team knew when she got kicked off.
What happened when Mr. Brackman found out?
Well, like I said, Mr. Brackman kicked her off of the team. And this really put the rest of the team in a tight spot because we had state coming up, and the rules for mock trial state that you can't make last minute substitutions. But in the end, this was no longer a problem because state got canceled.
I'd now like to talk about the text messages between you and Avery. Will you please reference Exhibit 14? Your Honor, permission to pull up what has been marked as Exhibit 14.
Any objection, Ms. Hunter?
No, Your Honor.
Permission granted.
Are these the text messages between you and Avery?
Yes, they are.
What was this conversation about?
So Avery had texted me about trying to convince Mr. Brackman to let her back onto the team, but he didn't have any intention to do so.
And what was Avery's response to this?
Avery said if Mr. Brackman was upset about what I did to his car, just wait and see what I do to his house.
Thank you, Your Honor. No further questions at this time.
Thank you, Ms. Inks. Cross-examination?
Yes, Your Honor. May I proceed?
You may. Thank you.
You were on the mock trial team with Avery Becker.
That's correct.
You spent a lot of time working hard on the mock trial team.
I did.
Avery excelled in mock trial with very little preparation.
That is also correct.
And it bothered you considering you put more effort in than Avery?
It didn't just bother me, it bothered the whole team.
And it also bothered you because you were not as successful as Avery?
Well, I was bothered by the fact that I was putting in more work and it wasn't being reciprocated and shown.
And understandably, it irked you when Avery would come in and make things up on the fly.
It did. It also bothered Mr. Brackman because he stressed the being properly prepared.
Avery won some awards at mock trial.
Objection, Your Honor, relevance.
Ms. Hunter?
Your Honor, the Ms. Cifuentes' response to Avery winning these awards is very relevant to the case.
How?
If you would allow me to ask my next question.
I've got to deal with this objection first. Tell me how you think it's relevant.
Well, the way Ms. Cifuentes reacted to the question was in anger, which shows possible bias against Avery.
Your Honor, a brief response.
You may.
I don't believe that the attorney has laid enough foundation to testify to this. I believe that this question it has been given with no foundation behind it. Therefore, its relevance is questioned as there's been no further explanation.
Objection is overruled. You may continue on, Ms. Hunter.
Okay. Avery won some awards at mock trial.
That is correct.
And you thought that Avery won because of good looks and not actual talent?
I did say that.
After Avery was kicked off the team, you said you would try to convince Coach Brackman to let Avery back on.
And I did.
However, you also thought that the team was better off without Avery?
Yes, because Avery constantly left the team in conflicting situations.
You were excited that you'd be getting a larger role with Avery gone?
Yeah, who wouldn't be?
And Coach Brackman didn't end up letting Avery back on the team?
No, he did not.
Because you were on mock trial, would you say you're familiar with court proceedings?
Correct.
Following the death of Coach Brackman, Detective Markowitz called you?
That is correct.
And he asked, Detective Markowitz asked if you could come in for an interview?
Yes, she did ask me.
You failed to bring your phone to that interview?
Yes, because I had left it on the charger that day to make sure it would be sufficiently charged because it was having battery issues.
When Detective Markowitz learned you didn't have your phone, he instructed you to send screenshots of the text messages instead?
Yes, she did.
Detective Markowitz has never seen this text conversation on your physical phone?
She has seen the text, well, she has seen the conversation, just not directly off of the phone.
The only place these text messages existed was on your phone and supposedly Avery's, correct?
Correct.
And you traded your phone away?
I did.
So there's no way to verify your testimony about the existence of the original text messages?
The screenshots I sent in are the original text messages. That's verification.
So not only is your phone gone, but Avery's phone is gone?
Apparently so, yes.
You were playing a game on her phone at the Fry Shack?
I was.
And this was the day before Avery lost it?
That's correct.
You had access to Avery's phone the day before Coach Brackman's death?
I did have access to it.
You had access to Avery's phone the day that Avery's phone went missing?
Correct, but I didn't take it or do anything with it besides play the game.
The only information from Avery's phone or your phone in this trial is a screenshot you made of a text conversation no one else has ever seen?
I didn't make screenshots, I took them.
On March 5th, 2020, the day before Coach Brackman's death, one of the last people to handle Avery's phone was you?
Correct.
Your Honor, no further questions.
Redirect examination. Ms. Inks?
There is actually no time for redirect.
All right, thank you. I appreciate that. That was the timekeeper advising that there's no time left for redirect. So that completes the examination of Ms. Cifuentes. Ms. Cifuentes, you may disable your camera and your microphone, and we appreciate your testimony here this afternoon. I'll again pause to allow scorers to score. All right, we'll now proceed with the defense case. Does the defense wish to present any evidence?
I'm sorry, Your Honor, are you asking for a witness to stand or?
Yes. Who do you wish to present evidence? And if so, who would you like to call as a witness?
Yes, Your Honor, the defense would like to call Avery Becker to the stand.
All right. And that is Ms. Hartman.
Yes, Your Honor.
Bear with me. And who will be handling cross-examination for the people?
That would be me, Your Honor.
Is that Mr. Dahman?
Yes, Your Honor.
Thank you. And who will be our witness here? Give me the name again of the witness, Ms. Hartman.
Your Honor, that would be Crystal Caruana.
All right. And is that the witness name or the actual name?
I'm sorry, Your Honor, that's the actual name. Crystal will be playing Avery Becker.
All right. So the witness is real name Caruana, and this is the defendant, Ms. Becker. Ms. Hartman, you may begin your examination.
Thank you, Your Honor.
Yeah.
Good morning, Ms. Becker. Please state your name and spell your last for the record.
My name is Avery Becker. That's Becker.
And who are you?
I am a former student of Colorado High School and also a former attorney from the CHS mock trial team.
Why are you here today?
Honestly, at this point, I'm asking myself the same question. Currently, I'm being accused of something unimaginably sick and horrendous that happened to my coach.
How would you describe your relationship with your coach?
Me and Brackman had our ups and downs. We didn't get along too well all the time because we clashed. He wasn't a fan of my work ethic, and sometimes he got frustrated when I performed well at competitions without putting in all of the work that he expected me to.
How long did you compete for Mr. Brackman?
I competed for coach for all 4 years. I started my freshman year as a way to kind of get out of the house, and after a while, I developed a passion for it, so I continued up until I graduated last year.
Now, you mentioned that you and your coach had a rocky relationship. What caused that strain?
Well, for example, after my regional tournament last year, I decided to play a prank on him, and I wrote in his car on what I thought was dry erase marker.
And how did he react to that incident?
He was pretty furious. He was so upset actually that he kicked me off of the team. It ended up being permanent marker, and I tried to express how sorry I was at the time, but I was never able to do it in person. It was supposed to be a lighthearted prank, but I never really got the chance to apologize for it.
So what did you do after that?
I did everything I could to try to make things right for him. I offered to scrub off the marker myself or work this summer and save up money to get his car repainted, anything to show how truly sorry I am. But he said that I could just join that loser Taylor Perkins.
Who is Taylor Perkins?
Taylor's my best friend. We joined a mock trial together our freshman year to hang out more frequently, and getting kicked off the team together allowed us to spend a little more time together.
Where were you on March 5th, 2020?
On March 5th, I went out with Taylor. We went to the Fry Shack and saw some teammates there. And after that, we went to the mall for a while. But towards the end of the day, I lost track of my phone.
And what happened on the following day? That would be March 6th.
On the 6th, me and Taylor actually decided to call off school to look for my phone. We checked back at the Fry Shack where we had eaten. That was the last place I remember having it. And then we checked the mall, but Taylor kept calling it and it went straight to voicemail. So I had just assumed that it was dead somewhere or stolen.
Stolen? Who would have wanted to or had the opportunity to steal your phone?
Objection, speculation.
Any response?
Your Honor, under the, this is not speculation because it's the witnesses. I'm sorry, can I have a minute to confer with co-counsel?
You may.
Okay, Your Honor. This is the witness's observation of the of her experiences during that day, and I'm only asking her to share her ideas on the events leading to her phone being missing.
The objection is sustained temporarily. I'll allow you to try and lay some additional foundation, Ms. Hartman, for why you think she can, based upon her observations and based upon her experience and observations and the facts that occurred, why this would not amount to speculation. So you may lay some additional foundation if you wish to. Otherwise, this objection is sustained.
Avery, who was at the Fry Shack?
As I said, there was a couple of teammates there, including Taylor and Alex Cifuentes.
Did you have any interaction with Alex Cifuentes?
Yes, actually, I let her play some games on my phone, and that's the last time I actually recall having my phone.
And who is Alex?
Alex is another one of my teammates from mock trial, but we didn't get along too well.
And why is that?
I felt like Alex didn't really want me on the team because maybe she thought that I would get best attorney again or something like that. It really seemed like she wanted that award.
If Mr. Brackman was here today, what would you say to him?
If Coach was here, I'd probably say that I'm so sorry that I put our team in jeopardy, and I'm sorry that I acted as childish as I did while I was on the team. And I wish I could have proved myself to him while he was still here, or at least apologize to his face.
Your Honor, I have no further questions for this witness at this time.
Thank you. Cross-examination?
Yes, Your Honor.
Mr. Dahman.
Ms. Becker, you've been on the Colorado High School mock trial team for 4 years now, is that correct?
Yes, I have.
Mackenzie Brockman was your coach?
Yes, for all 4 years.
You would often call your work lazy.
Yes, as I said before, me and Brackman had a pretty rocky relationship because he wasn't a fan of my work ethic. I tend to do things on the fly, and I still find success that way, so that's what I stuck with. But his thought process was just different from mine.
That you didn't put in the work?
I didn't put in what he considers as work. However, I did still succeed in our competition. So in my opinion, I did put in enough work for me to succeed, so.
Yes or no? That you did not put in the work?
Oh yes, I did put in the work, and that's how I got awarded Best Attorney at regionals and state.
He would always rewrite everything you did?
He would try to rewrite. As I said before, we had a pretty different thought process on how we wanted to do things. So I didn't really think it was okay for my team to succeed due to scripts written from our coaches. So I tried to develop our case as much as we could individually.
Thank you for that response, but my question was yes or no. He always rewrote everything you did. Yes or no?
Tried, however, I did use my own content primarily.
Objection, Your Honor. I request.
What's the objection?
I request that the co-counsel lets my witness answer in entirety.
All right. It's cross-examination. He's permitted to ask leading questions, including asking for a yes or no response. However, he controls the question and not the answer. So the witness can answer as she deems appropriate. If she's able to answer it in yes or no, the court's expectation is she will. If she can't, the court's expectation is that she'll advise us of that. Mr. Dahman, you may continue.
Ms. Becker, you thought that Mr. Brockman's ego was really something, right?
Yes, I did. I believe that Brackman sort of viewed himself as superior, even though, you know, he was, in a sense, he was an actual attorney, and it was probably me just being childish in high school, but I did say that, yes.
Even going to call Mackenzie Brockman a joke?
Yes.
A month before your regional tournament, Coach Brockman complained about your lack of preparation. Is that correct?
Yes, he did. He complained about my practicing and how that I wasn't doing my work exactly how he wanted me to do it.
You started to say something back, but were promptly cut off. Yes?
Yes, I was.
You were then promptly promoted to the B team. Is that correct?
Yes, Brackman put me on the B team in order to separate me from my best friend. He thought that we might have more success while we were on different teams.
Later, Taylor Perkins, your best friend, contacted you saying, if I quit, Coach will have no choice but to put me back on the A team. Is that correct?
Yes, Taylor, he didn't really enjoy mock trial as much anymore. And he told me that he didn't really want to be on the team, so that's why he left.
And you're best friends with Taylor Perkins. Is that correct?
Oh, absolutely.
And on March 6th, you and Taylor supposedly skipped school?
Yes, we called off school in order to look for my cell phone.
That you claimed to have lost the day before?
Yes, I did lose my phone.
You went to the mall?
Yes, I went to the mall after the Fry Shack.
And then the Fry Shack?
Yes.
But you did not find your cell phone?
No, I did not. As I said, me and Taylor tried to call it and contact it, but it just went straight to voicemail, so I just assumed it was dead or stolen.
During that entire time, you were only with Taylor, is that correct?
Yes, we didn't develop a search party for my phone. It was kind of just we were looking for it that day.
Taylor's the only one here who can testify to your alibi, is that correct?
For looking for my phone, I suppose.
You have no physical evidence to support that you went to the Fry Shack or the mall.
No, but what evidence would you expect me to have from looking for my phone at the mall or the Fry Shack?
You don't have any CCTV footage?
No, that would have to be taken from the Fry Shack or the mall cameras, so I'm not able to get that content.
Nor did you get any receipts from the mall or the Fry Shack?
No, I just went to look for my phone. I wasn't buying anything.
Moving on, after your regional tournament, Mackenzie Brockman thought you didn't deserve the Best Attorney Award. Is that correct?
Objection, Your Honor. Relevance.
Response to the objection?
Your Honor, I'm laying foundation to show possible motive for the witness that she thought that she did well, which could go to anger and motive to get back at Mackenzie Brockman as accordance with Exhibit 14.
All right. Objection's overruled. You may continue on. Mr. Diamond?
Let me re-ask my question. After your regional tournament, Mackenzie Brockman said that you didn't deserve your Best Attorney Award. Is that correct?
Yes, Brockman said I didn't deserve it after I was already awarded it by the regional competition, so.
That you exclusively relied on your looks?
He did say that, even though that's completely inaccurate, and I do find that pretty disrespectful because I feel like I really worked hard for my position on my mock trial team, and I worked hard to get the awards that I did earn on my regional competition as well.
You thought your coach would congratulate you?
I did at first because I thought that the point of mock trial was to succeed and to make it further in the competition. However, he was not impressed by the award that I received.
And that made you angry?
Yes, I suppose. I kind of just wanted my coach to be proud of me. I had worked pretty hard during the season, and I just thought maybe it's vain of me to think this, but I kind of just wanted a congratulations or something like that from my coach.
You didn't want to be insulted?
No.
You stormed out of practice?
Yes, I did. I was pretty upset after that.
With a black marker in your hand?
Yes.
You wrote in giant letters across the hood of Mackenzie Brockman's porch, is that correct?
Yes, and as I said before, I was pretty upset. I thought it was an expo marker at first, and in hindsight, it was pretty childish and definitely a mistake that I should not have done, but it's pretty easy to make rash decisions when you're upset. So I did write on his car with what I thought was an expo marker, and it ended up being a permanent marker. As I stated previously in my direct, I did try to get his car repainted and get it off myself, but he would not let me do that.
Is that a yes or a no?
That was an affirmative statement, yeah.
You wrote Worst Attorney Award, is that correct?
Yes, I did.
You thought that this would really show what you thought?
Yes, I suppose.
Then Mackenzie Brockman came up behind you?
Yes.
Then he started shouting?
Yes, he did.
He shouted, "What did you do to my car?"
Yes, Brackman got pretty upset with me, and after that, I was terminated from the team completely.
He continued shouting, "You're off the team. You can join that loser Taylor Perkins and play video games all the time." Is that correct?
Yes, I did. I was pretty upset at this point in time. I thought it was a little childish of my coach to be calling a high schooler a loser, and so I was pretty upset at the time.
And that made you even angrier.
As I just said, yes.
You then went home and talked to your mother.
I did.
You didn't mention what you did to Mackenzie Brockman's car.
No, I did not at that point in time.
You told your mother you would get back at him if it was the last thing you did.
As I said before, yes, I did say that, but people do say things they don't mean when they're upset, and that definitely was a point in time where I did say that.
Is that a yes or a no?
I said yes at the beginning of my sentence.
Thank you. No further questions at this time, Your Honor.
Thank you, Mr. Diamond. Redirect examination.
I don't believe any is necessary, Your Honor. And I ask, barring any recross, which there wouldn't be, that my witness be excused from the stand.
All right. Ms. Becker, we appreciate your testimony here today. You may step down. Thank you. And we'll take a brief pause to allow scoring. Again, scores, I think there's an error in the scoring card. Bear with me. Again, I'm looking at the portion of the scorecard, which would be the last page. And on the left-hand side, we have plaintiff's counsel, plaintiff's first witness, etc. And then below that, we have defense counsel, cross-examination, plaintiff 1. Perhaps the score, I'm confused here. It looks to me like that should be for defense 1. Or perhaps I have been scoring it. I may have been filling it out wrong. So I'm confused there as to where we are listing defense witnesses.
Judge, this is Jason Downey, the coordinator. Over on everything for the plaintiff is on that left-hand side. So for this questioning of this witness, if this is the defense first witness, the witness's performance is scored over there where it says witness performance D1. That would be how you score that witness. The direct examination by the defense attorney would be the box directly above that. That's how the defense attorney does on direct examination. And then the plaintiff's attorney would be doing the cross-examination, and they're on the left-hand side of the ledger. So they are cross-examination by plaintiff's attorney or prosecution attorney 1. Does that make sense?
I think it does, yes. So we should be looking at the right-hand side. In effect, this is defense witness 1 as identified there. And that P1 does not refer to a witness number. It's just it's the lawyer who did the cross-examination of defense exhibit 1.
Correct.
Okay, so
but it looks like there's no place to put the names of the cross-examining student attorneys. There's a place for the score, but no place to list their names.
That's correct. And the state did this score sheet, and at the top, that's where they want you to put all the names. And then below, this is just for scores. If you fill out the scores, you can cross-reference and figure out who it was up here. I noted the one error you mentioned earlier, Judge, it says plaintiff's witness 1 twice, essentially. And that needs to be changed to plaintiff's witness 3. I've notified the state about that. And you're right, Mr. Straight, there is no place for you to put the names down here. You just need to score in the points.
Mr. Downey, that was really helpful to me. I feel like I'm squared away. Other scorers feel like they understand what's going on, or let me ask it this way. Is there anybody who has any confusion on the scoring as we transition to the defense witnesses? Okay, I think we're in good shape then, and we'll proceed to the next defense witness. Defense may call their next witness.
Your Honor, the defense calls Taylor Perkins to the stand.
And that's Mr. DeSalvo. You'll be conducting the examination of Ms. Perkins?
Yes, Your Honor.
All right. And who will be conducting cross-examination?
I will, Your Honor.
And that's Mr. Mayer?
Yes.
And who is our witness?
Oh, I am.
All right. And that is Mr. Onwuka? And you will be the witness, Taylor Perkins?
Yes, Your Honor.
All right. Welcome, Mr. Perkins. I'll remind you that you are under oath, and you may begin your examination. Mr. DeSalvo.
Thank you, Your Honor. Please state your name and spell your last for the record.
My name is Taylor Perkins, Perkins.
And who are you?
I am Avery Becker's best friend, and I was on the mock trial team with him.
And why are you testifying today?
The reason why I'm testifying today is because I was with Avery Becker during the time the crime occurred, and I can attest to his character and his habits.
And how would you describe her, Avery Becker?
I would describe Avery Becker as a talented individual. He was my best friend, and he introduced me to mock trial. He was a natural at it, so it meant more to him than it did to me. That's why it was unfortunate when, towards the end of our senior year, he lost his position on the team.
Once Avery was kicked off the mock trial team, who did she text to get back on?
When Avery was kicked off the mock trial team, she texted everyone she could to try to help her convince Coach Brackman to put her back on the team. She even texted Alex Cifuentes.
And how did Avery feel about Alex?
On the surface, Alex and Avery had a decent relationship, but we all knew that wasn't the case deep down. Alex had the tendency of being insincere and passive-aggressive. He always wanted the roles that Avery had, and with Avery gone, he got the chance he wanted.
Objection, Your Honor. Speculation.
Any response to the speculation objection, Mr. DeSalvo?
Well, Your Honor, my witness was just finishing up, but to respond to the speculation objection, under Rule 701, this is Mr. Perkins' rationally based perception. Given that he is best friends with Avery Becker, it would be, his information in regard to how Avery feels about someone that both of them know fairly well.
Your Honor.
Any reply, Mr. Mayer?
Yes, Your Honor. The witness just testified to the disdain from Avery to Alex, that their relationship wasn't as good as it seemed. So in that case, I would say that there would be bias towards Alex's own opinions of Avery from the defendant and or the witness on stand.
All right, the court concludes the issue of bias may be drawn out on cross-examination, but it does not foreclose him from giving his perceptions based upon his observations and knowledge of the relationship with his friend. So the objection is overruled. The court concludes it's not speculation, but you may test those issues on cross-examination.
Yes, Your Honor.
Mr. DeSalvo, you may continue.
Mr. Perkins, would you like me to re-ask the question so you can finish?
Yes, please.
How did Avery feel about Alex?
On the surface, Alex and Avery had a decent relationship, but we all knew that wasn't the case deep down. I mean, Alex had the tendency of being insincere and passive-aggressive. He always wanted the roles that Avery had, and with Avery gone, he finally got the chance he wanted to shine, and he wouldn't want to give that up.
And what did you do that Thursday after school?
After school on Thursday, Avery went to the mock trial practice to try to talk to coach, but she was told to leave. So she came to my house and we hung out and played games on our phone.
And what happened later that evening?
Later that evening, we got hungry, so we decided to go to the fry shack to get something to eat. That turned out to not be the best idea though, because while we were there, most of the mock trial team showed up, and they were all telling Avery how unfair coach was being by kicking her off the team.
Where did Avery go?
Avery got upset and ran off to the bathroom. She left her phone behind, which wasn't in character for her.
And how did you know that Avery was really upset?
Avery leaving her phone behind showed just how upset she was. She always had her phone on her, and if not, it was never too far out of reach. It was like her third kidney in a sense.
So on March 6th, the day Avery picked you up for school, what did she respond with through text beforehand?
On the days when we both had, Avery usually picked me up and rode with me to school that morning, in mornings. Excuse me, could you re-ask the question?
Yes. So on March 6th, when Avery picked you up for school, what did she respond with through text beforehand, if at all?
I usually rode with Avery on the morning to school, especially on the days when we both had first period off. That's why I thought it was weird when Avery hadn't answered my text that morning about whether or not we were riding together. It was only when I asked her about it that we realized that Avery's phone was missing.
And did you go look for the missing phone?
Yes, Avery and I went to the mall to search for Avery's phone. We checked every store that we had been to, and when we still couldn't find it, we went to the fry shack to see if they had seen it.
What else did you do to try to find the phone?
Along with retracing our steps, Avery and I used my phone multiple times to try to call and text Avery's phone while we were out looking for it.
And how long did you spend looking for the phone?
Avery and I spent the entire day looking for the phone, and when we still couldn't find it, we went to the fry shack to check with the afternoon shift to see if they had seen it. We were surprised to see the mock trial team when we were there, though, because they were supposed to be at practice.
And who is Blair Rollins, and how would you describe him?
Objection, Your Honor. Lacks foundation.
Any response to the objection?
I could lay more foundation for it, Your Honor.
You may. Go ahead.
Who is Blair Rollins?
Blair Rollins.
Objection, Your Honor. Or there's still no foundation for Blair Rollins in the court.
All right, the objection's overruled. I think he's laying a foundation for the question that he's going to ask. I don't find there to be anything speculative or inappropriate about asking who this individual is. You may go ahead and continue.
Blair Rollins was a student at our school, and he was kind of weird. He had a reputation for hating Coach Brackman, especially since Coach had lost the case that sent Blair's father to prison. Blair was the type to become a hitman or a sociopath in the future, so it wouldn't be too far of a stretch to say that he could do something like that with no remorse.
And lastly, Mr. Perkins, who was with you on the day of March 6th, the day in which Mr. Brackman was unfortunately murdered?
I spent the entire day of March 6th with Avery Becker searching for her phone. Avery and I were nowhere near Coach Brackman's house, and I know that Avery had nothing to do with Coach's murder, and I know that for a fact. I'm here to tell the truth and nothing but the truth. I wouldn't lie for Avery, and especially not about something like this.
Thank you, Mr. Perkins. No further direct at this time, Your Honor.
Thank you. Mr. Mayor, cross-examination?
Yes, Your Honor. Mr. Perkins, you're here to testify for your best friend, Avery Becker?
Yes, that is correct.
And she was the only reason why you were on the mock trial team?
She wasn't the only reason. She introduced me to it, but I stayed because I was semi-interested in it, and who wouldn't want to do something with their best friend?
So, yes or no?
Yes.
And when Avery got demoted to B team, you quit?
Yes, that's correct, because I wasn't super duper interested in mock trial, and since it was more important to her than it was to me and it wasn't hurting anyone, I just decided to step down.
And you quit so a spot would open up on A team.
Yes, that is correct.
A spot that would be able to be used for Avery.
Yes, that is correct.
And you knew Avery would get that spot.
Yes, I knew Avery would get that spot because she was talented at mock trial. She was a natural at it and she had the awards to show it.
And you did this because she's your best friend.
Yes, that is correct.
Later on, Avery and Mr. Breckman had gotten into a fight.
Yes, that's true.
A fight where Avery wrote on Mr. Breckman's car.
Yes, that is correct. She thought the marker was dry erase.
She wrote in big letters the worst attorney award on his Porsche.
Yes, like I said, she was upset that she'd been removed off of the team, and so using what she had presumed was a dry erase marker, she wrote that on his car.
In permanent marker.
Yes, the marker was permanent, but she thought that it was a dry erase marker.
And she got kicked off the team for this.
Yes, that is correct.
Which you think is unfair.
I would say that it's unfair to kick her off the team, especially since it was her senior year and she was so talented at it.
And this led to you guys trying to find ways for her to get back on the team.
Yes, that is correct.
Where she then texted everyone.
Yes, that is correct.
Including Alex Cifuentes.
Yes, that is correct.
And neither of you liked Alex Cifuentes.
I wouldn't necessarily say that we didn't like Alex. There was just some disagreements due to the clashing of personalities, but Avery really enjoyed mock trial, and so she wanted to do everything she could to try to get back on the team.
So yes or no?
Yes.
And after being rejected by Mr. Brackman, she came to your house.
Yes, that is correct.
Where you guys then went to the Fry Shack.
Yes.
Where you saw most of the mock trial kids.
Yes, that is true.
Even Alex was there.
Yes, that is correct.
And Alex had made Avery mad, so she stormed off.
Alex hadn't necessarily made her mad. Alex being there and everyone bringing up how it was unfair that she'd been removed from the team, she was upset with that statement, so she ran off to the bathroom.
And after she stormed off, you wanted to punch Alex in the face.
I wouldn't necessarily say that I wanted to hurt Alex. I was just upset at him for making Avery upset.
So is that a yes or a no?
Yes.
And Avery happened to leave her phone on the table.
Yes, that is correct.
Then you guys left.
Yes, we left because Avery was upset and it just wasn't a good place for her to be.
And you refer to Avery's phone as a third kidney?
Yes, that is correct.
Finally, you want the jury here to believe that Avery Becker left her third kidney on a table.
Objection, relevance, Your Honor.
Any response?
Your Honor, I am bringing up stuff that was brought up on direct. I'm just clarifying for the jury that this is what they want in what their testimony is here to do today.
I think it's a relevance objection. Any response to the relevancy of the question and anticipated answer?
Yes, Your Honor. I believe it's relevant because this is talking about the phone that is an essential part of their case in order to prove that they left a phone somewhere. I am strictly asking about that.
Objection is overruled. You may re-ask your question.
Finally, Mr. Perkins, you want the jury to believe that she just left her third kidney on a table.
The term third kidney was a bit of an exaggeration, but Avery always had her phone with her, and since she was upset, it was not too hard to see that she could overlook it.
So that's a yes?
Yes, that's correct.
No further questions at this time, Your Honor.
Thank you. Any redirect? Mr. DeSalvo?
Yes, Your Honor, just a brief one.
You may go ahead.
Mr. Perkins, in the heat of the moment when emotions and tensions are high, would it be at all possible, knowing Avery Becker yourself, that she could storm off to the bathroom forgetting her phone?
Objection, Your Honor. Leading questions.
Any response to the objection?
Your Honor, I could re-ask the question.
You may.
Mr. Perkins, is it at all possible in the heat of the moment for a person to leave something that is, with them most of the time on a table?
Yes, of
Your
course.
Honor, I would call leading again and speculation.
Objection's overruled. You may go ahead and answer.
Yes, I think that if someone was upset, it wouldn't be too hard to imagine them leaving something behind. Because when you're upset, you don't think the way you normally do, and you deviate from regular habits.
Thank you, Mr. Perkins. And Your Honor, barring any recross, I would ask that Mr. Perkins be excused from the witness stand.
Any request for recross?
Yes, Your Honor, very brief. Mr.
Very
Perkins,
brief recross.
Mr. Perkins, on redirect, you say that people can act out of character while enraged, correct?
I didn't say that people could act out of character within rage. I said when they're upset.
Sorry, if they're upset, they can act out of character.
Yes, that is correct.
Meaning Mrs. Becker could have been acting out of character when she murdered Mr. Brackman.
Avery wasn't irrational enough to do something like that. Her leaving her phone behind doesn't correlate to her committing a murder.
No further questions at this time, Your Honor.
Thank you. Mr. Perkins, we appreciate your testimony. You now may step down and disable your camera and your microphone. Thank you. We'll pause for permitting scoring. The defense may call its next witness.
Your Honor, the defense would like to call Blake Van Owen to the stand.
Van Owens? That's Miss Hunter, right?
No, that's Miss Maurer.
All right. I'm sorry. Who's speaking to me right now? That's Miss Hunter, right?
Yes.
All right. And the witness, Miss Van Owens, is being played by Miss Maurer, am I correct?
Yes, Your Honor.
All right. And who will be handling cross-examination for the people?
That would be me, Your Honor.
And that would be Miss Inks, right?
Yes, Your Honor.
All right. And Miss Maurer, are you able to turn on your camera?
Yes, Your Honor. It's on.
All right. So, Ms. Van Owen, I'll remind you that you remain under oath. You may begin the examination, Ms. Hunter.
Yes, Your Honor. What is your name and spell the last for the record?
My name is Blake Van Owen, Vanowen.
What do you do, Professor?
I'm a private investigator, professor, and expert witness in police practices.
Where do you work momentarily?
I'm a professor at CU Denver and have been teaching a course on police practices for about 5 years.
5 years ago, before being a professor in police practices, what was your profession?
I worked in the police force for 9 months, and then I went to private investigation. As I was working, I started teaching classes on police procedures at the Community College of the Rockies, which is how I started to get into teaching.
Did you ever get a degree?
Yes, I got a master's degree from Ashford University for criminal defense.
Have you testified in court before?
I have in over 100 cases for the defense. This case is not any different than the many others I've testified in.
In those 100 cases, where were you accepted as an expert?
I've been accepted as a defense expert in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and in state courts in Colorado, Wyoming, Nebraska, and New Mexico.
Where have you testified before?
I've been accepted by various courts as an expert in 8 times in crime reconstruction, 5 times in cell tower analysis, and 12 times in general police investigation tactics.
Why have you only testified for the defense?
The reason is most prosecution attorneys use police personnel as witnesses to testify. I've worked with the police and know how they work and operate through cases, as I've testified in over 100.
Tell us about your income as an expert witness.
I charged $225 per hour for research, writing, and investigation work, and $450 per hour for depositions and testimonies. I only ever charge by the hour and am not paid for winning.
Your Honor, the defense would like to enter this witness in as an expert in police investigation, crime scene reconstruction, and cell tower analysis with an emphasis on crime scene reconstruction based on her training, expertise, or experience.
Any objection to the proffer?
A brief voir dire.
You may. Ms. Hinks?
Yes. Previously, you worked at the Aurora Police Department.
Yes, I did.
But later quit your job.
I did due to an accident.
And you have not worked under a police department since?
No, I've not.
And you only worked as a police officer for 6 months?
9 months.
You've not been recertified in your practices since?
No.
8 years ago when you worked at the police department?
Yes, that's correct.
And you were unaware of the procedures that have been put in place since you left?
Yes, that is correct.
Your Honor, at this time, I don't object to this witness being entered in as an expert as long as they stay within the scope of their expertise that they're being entered as.
Thank you. I don't have an objection to the qualifications. So Ms. Van Owen will be qualified as an expert in the field of crime reconstruction, police practices, and cell tower analysis, and she may give opinion testimony in those fields. Ms. Hunter, you may continue.
What were you asked to testify on in this case?
I'm testifying on another theory of how Brackman was stabbed, how the evidence of the cell towers do not prove that Becker was there at the murder scene, and to establish that the prosecution's case is unsound.
What did you review in this case?
I've reviewed the police reports, the crime reconstruction conducted by Kyle Cusack, as well as the cell tower reports and exhibits prepared by Detective Markowitz.
Did you conduct a personal investigation?
Yes, I did conduct my own partial investigation in certain areas that I believed were neglected by the police. Based on my training and experience, it is beyond argument here that the police investigation was rushed.
Where did you keep your work?
A copy of my findings are kept in my report.
Would you recognize this report if I provided it for you?
I would.
Your Honor, permission to present opposing counsel and my witness with what has been marked as Exhibit 20?
Any objection to that?
No, Your Honor.
You may do so.
Let the record reflect that opposing counsel has been presented with Exhibit 20.
It shall.
Is you signed this report?
I did.
Tell us about this exhibit.
This is my report where I've kept my findings and observations on the case of my own partial investigation.
When did you write this report?
I wrote this report after I gathered all of my findings from my investigation.
Your Honor, the defense moves to enter Exhibit 20 into evidence.
Any objection to Exhibit 20?
Yes, Your Honor, I object on the grounds of hearsay under Rule 8035C, the adverse party clause.
Bear with me. Where in the rule book is 8035C?
I have, it should be in the rules of evidence. It states.
Thank you. I'm having it. Bear with me while I catch up with you. 8035C is a recorded recollection. So I'm not sure the basis of the objection, Ms. Inks. Tell me again.
I'm sorry, I misspoke. I'm sorry. I'm responding, or I object to hearsay on the document. I'm sorry, that was my bad.
All right. The objection is hearsay. Any response to the hearsay objection?
Yes, Your Honor. Under Rule 803-6, A through E, because this record was made at an appropriate time, this was made by an expert, and the source of information does not contain a lack of trustworthiness, this is not hearsay.
Have you laid an adequate foundation for 803-6? That is records of regularly conducted activity.
Yes, Your Honor.
So far, the objection is sustained. I will give you leave to try and lay a foundation so that we have an evidentiary basis for concluding that it is a record of a regularly conducted activity. But I haven't heard that evidence yet.
Yes, Your Honor. Ms. Van Owen, when did you write this report?
This was after I had concluded my own investigation, and all of my findings of the proceedings are included.
Do you make these investigations regularly?
I do. I've testified in many cases, and so I've had much experience with this.
And this record was written near the time of Mr. Brackman's death?
Objection, Your Honor, leading question.
Any response to the objection? Hold on. Any response to the objection?
Yes, Your Honor, I can rephrase.
You're allowed to lead for purposes of establishing foundation. That is an exception to the rule against leading questions. So you can continue to lead to lay the foundation if you wish. The objection is overruled. You may go ahead.
Ms. Van Owen, this record, you wrote regularly? You write records like this regularly?
I do.
And you are an expert in all the fields which you spoke about in this report?
Yes, I am.
Your Honor, I would now like to enter this exhibit into evidence.
Relying on 803-6?
Yes, Your Honor.
Any response to the proffer?
I still stand by my objection on hearsay.
All right, the objection is overruled. The court concludes that an adequate foundation has been laid to establish that this is a record of a regularly conducted activity by this witness in her professional capacity, and that an adequate foundation exists under 803-6, which is an exception to the hearsay rule. Exhibit 20 is therefore admitted and it may be published.
May I direct your attention to page 83? Sorry, the next page, 84. Do you have another theory of how he was stabbed?
Yes, the most likely scenario is that Brackman was stabbed in a seated position from behind.
You can get rid of the exhibit. What are those reasons?
The direction of force was applied downward and toward the aorta.
What does this suggest?
This suggests that the assailant was positioned above the victim as if standing behind the victim who was seated, unlike what the prosecution has thought to be true in this case.
How did you come to these conclusions?
The autopsy shows that the sharp side was pointed downward. The most likely scenario was for the knife to be held in like the position shown in the movie Psycho.
Why do you believe that Brackman was surprised by the intruder?
For the assailant to match the description, there's no way that they could have performed the bear hug stance to stab Brackman in an attempt to wrest the knife out of his hands.
Why?
The assailant was about the same size as Brackman. Because of the intruder's stature, the only logical way for them to stand over the victim and exert much forward pressure to be able to stab through the scapula and nick the aorta. This leads me to believe that Brackman was surprised.
Why does the prosecution not believe this as well?
They do not believe this way for two reasons. First of all, the scuff marks, which they believe show a struggle, and the ring videos, which could have alerted Brackman of the intruder.
What is your opinion on the ring notifications that supposedly alerted Brackman?
The prosecution believes that the victim has a ring doorbell, and they immediately assumed that it notified Brackman and that he was able to arm himself.
Why do you think differently?
We do not know for the fact that the ring notified him. Detective Markowitz failed to obtain this critical information from the user settings of his phone, which he did have access to. The ring notifications can be turned on or off, and the app can be set up to not have notifications, but we will never know this.
What if the ring did notify him?
Even if this did happen, Mr. Brackman may not have been near his phone or may not have been paying attention to notifications, which do come in frequently.
What is the result of this?
Given the fact that Brackman may not have been notified of the intruder, Brackman would have not been armed readily and would have been caught unaware. This means the intruder would have most likely brought the weapon, which shows premeditation, and this points to another suspect with more motive.
What is your thinking on the murder weapon?
There are many differences between the ones in the knife blocks and the murder weapon. They aren't the same brand, nor are they the same build or type.
What does this prove?
This proves the knife most likely came from another source, meaning the intruder, which shows premeditation if they'd brought another weapon, leading to another suspect.
Tell us about the scuff marks.
The police have noticed the scuff marks on the floor and immediately thought it was a result from a struggle. Once again, this is backed up without any hint of evidence. The marks could have been there for a while before this incident. Scuff marks cannot be carbon dated.
And what of the broken plate?
This could have easily been a result of being surprised. Brackman could have dropped it out of shock. This does not prove a struggle.
Why do you believe these observations to be true?
There were no eyewitnesses to the murder, so no one can know what happened. But when you're trying to piece together a puzzle, you can't put a piece down where it doesn't fit. We do not hold the burden of proof today, but the opposing counsel does. And if you can't back something up without at least some proof or common sense, it shows deep holes in your case.
How does this affect the case?
This greatly affects the case. In investigation, you never, ever assume, but the prosecution did just that. They went straight for the easiest and most convenient explanation. There isn't just much proof to the prosecution's theory of this case.
What can you tell us about the cell tower records?
In an urban area, a cell tower covers roughly a circular area with a 6-mile radius. There are 3 sectors in a cell tower, and each sector corresponds to a particular antenna mounted on the cell tower. As such, it is possible to identify which sector the phone locates and when it is communicating with a particular cell tower based on which antenna was being used.
How can you tell where the phone was located?
You cannot. A cell tower is not a GPS tracker. It only gives an approximate location of the phone. The phone could have been anywhere within a 38 square mile location at that time.
Could Avery's phone be connected to any of the towers?
Yes, a phone does not always connect to the nearest tower. It connects to one with the strongest signal when others are busy. The only information that we have is that Avery Becker was in contact with a cell tower near Mackenzie Brackman's residence near the likely time of murder.
Does this mean Avery was at the murder scene as Markowitz suggests?
No, absolutely not. The cell tower records do not show where the phone was located, only within a 6-mile radius approximation. This does not prove that the phone was at the murder scene, let alone Becker, who has an alibi.
How did you do things differently in this case?
They never considered any other options and jumped right to conclusions. I looked at all the facts and never ruled out any other possibilities until I got all the details. I only go where the evidence takes me, and this prosecution's case is unsound.
Why do you believe that the evidence points to another suspect?
I feel Blair Rollins is a person of interest that should be investigated immediately.
Why is that?
Rollins has a similar build to Becker, which matches the fit of the intruder in the ring videos. He also has suspiciously gone missing around the time of murder.
Besides Rollins' similar build, what else suggests this possibility?
Well, Rollins has a motive, which in my opinion was far stronger than the motive of Becker's.
What is the reason for his motive to murder Mr. Brackman?
You see, Brackman was a representative of Rollins' father, Johnny Rollins, at a trial for which he was sent to jail. There's an incriminating recording of Johnny stating that he would get back at Brackman if it's the last thing that he would do, making this a possibility the police once again failed to follow through with.
One final question. As an expert witness, from the evidence you've gathered, what is your professional opinion on the proceedings?
In my professional opinion, I know that there is a reasonable doubt surrounding the prosecution's theory of Becker and their entire case. I found multiple points of evidence that refute many of their conclusions. My observations and conclusions have been drawn from my extensive knowledge that I've gained throughout the years testifying and teaching.
Thank you. Your Honor, no further questions.
Thank you. Cross-examination.
Yes, Your Honor.
Ms. Inks?
Yes. Professor, you currently work as a private investigator.
I do.
You assisted the defense in building material for their case.
Yes.
To do this, you conducted your own investigation.
I did.
That you turned into a report for the court.
Yes.
This report was made after reviewing the case material provided by Detective Markowitz.
Yes, and as well as the information given by Kyle Kuzak.
And Kuzak. And you were present when they testified in court today?
Yes.
You were here when evidence was provided to prove that a physical altercation did occur.
Yes, but I've shown that many of those points could be refuted.
You heard both Markowitz and Kuzak attest to that.
Yes.
You also heard the testimony that points towards a knife from the residence being used in the murder.
Yes, but I also gave reasons why it may not have been.
That Kuzak stated in his direct.
Yes.
However, you disagree with this statement.
I do.
And on your own, you came up with your own theory.
Yes.
After being hired by the defense.
Correct.
Is this the first time that you've worked with the defense?
No, I've always worked with the defense.
In fact, you've only ever worked with the defense.
Yes, that is correct, as I previously stated.
And never in accordance with the prosecution.
No.
And each job that you take on has to hire you?
Yes.
As an independent investigator?
Yes, that is correct.
And because you operate independently, you get paid for your services?
I do.
And for this case, you were hired?
Yes.
And are being paid to write your own theory for them?
Yes, that is correct.
In fact, for this case, you have already received just under $7,000 for your theory.
Yes.
Moving on, I'd like to direct your attention to your time at the Aurora Police Department. Your work started at the Aurora Police Department?
Yes.
This job led to an incident on duty?
Yes.
In which you injured a young woman during an arrest?
Objection, improper character evidence.
Response, Ms. Inks?
Your Honor, I'm not using this to talk about the directly in the incident. I'm just bringing up as to why she ended up quitting her job at the police department.
Any reply?
No, Your Honor.
The objection is sustained. You may ask your next question.
This incident led you to quit your job in that department?
Yes, but I've been cleared of all wrongdoing.
And left you with a distaste for police procedures?
Yes, I do not agree with some of their policies that they use, and that's why I left.
Yet you came into this case knowing that police procedures were a major part of the evidence.
Right, and that's why I was trying to show all the things that they missed in this case.
Even though you disagree with police procedures?
Yes, I disagree with some of them.
And you have written a statement against the procedures for the defense's case?
Right.
Moving on to your prior knowledge of Kyle Kuzak. You knew Kyle Kuzak before this case?
Yes, I knew him professionally.
In fact, you've worked with him before?
Yes, I have.
Even before you were asked to give an opinion on this case?
Yes.
And you still agreed to give this opinion?
Yes.
With this prior connection?
Objection, relevance.
Counsel?
Your Honor, I am laying foundation to a question that shows bias against one of our own witnesses as her being an expert witness and giving testimony on this case.
All right, the objection's overruled. You may continue.
And you still agreed to give an opinion,
Yes, I did.
even with this prior connection,
Yes.
to a man that you find generally egotistical and full of himself.
Well, just because you may find someone a little haughty doesn't mean that I don't generally like him.
Is that a yes or a no?
I suppose you could say that.
Thank you, Your Honor. No further questions.
Thank you. Redirect examination?
Yes, Your Honor, a brief one.
Sure.
Did knowing Kyle Kuzak affect the way you conducted your investigation?
Objection, Your Honor. Leading question.
Any response?
Your Honor, I don't think that was a leading question. I asked, did knowing Kyle Kuzak affect your investigation? And I think my witness can expand on that.
A brief response.
Yes.
Your Honor, that did you calls for a yes or a no, which is calls for leading on this first question on redirect.
All right. The objection is overruled. Generally speaking, a leading question is one which suggests the answer in the question. And the court does not believe that this question does, and the court concludes it's a fair question. You may go ahead, Ms. Hunter.
Would you like me to repeat my question?
Yes.
Did knowing Kyle Kuzak affect the way you conducted your investigation?
No, not at all. I only looked at the facts, and my opinion was not rendered by any outside factors.
No further questions.
All right. Any brief recross?
No, Your Honor.
All right. We'll take a break for scoring again. Ms. Van Owens, we appreciate your testimony, and you may step down. It looks like you already have. Thank you. All right, we will now proceed with the closing statement from the people.
Yes, Your Honor.
This is Mr. Dahman.
Opposing counsel and members of the jury, revenge is a powerful motivator. Today, you have seen the whole truth and nothing but the truth, that Avery Becker acted on revenge to burglarize and vandalize Mackenzie Brockman's residence. However, as you've heard from numerous experts today, that burglary went wrong. So let's go back to the events on March 6th of 2020, before the events on March 6th of 2020, and look back at the relationship between Avery Becker and Mackenzie Brockman. Before all this, Avery Becker never really got along with her coach. They'd always disagree, rewrite everything she did, and always complain that her work ethic was lazy. We want to look back at the relationship between her and her team. She always put the team in a hard spot. That because of it, she got demoted, and she even got kicked off the team. With her rash anger, she vandalized Mackenzie Brockman's white Porsche, writing Worst Attorney Award on it. Even though she didn't believe that it was a permanent marker, the intent was still there to vandalize the residence, to vandalize the car, to vandalize property. It was the intent to do something. On March 6th of 2020, Avery Becker claimed to have been with Taylor Perkins and Avery Becker with herself and Taylor Perkins the entire day. However, we need to refer to Exhibit 15 and 15B when referring to the cell phone records that show Avery Becker's phone, as you heard from Detective Markowitz, from 12:45 to 1:17 p.m., she drove down Rock Creek Parkway to Mackenzie Brockman's residence. And as you saw in Exhibit 14, that she said that she would wait until he was at work to go break in and trash the house. That will show him. There was intent to break in and vandalize the Mackenzie Brockman's residence. That is second-degree burglary. You heard from Kyle Kuzak referencing Exhibits 9 and 18 that obviously show a sign of a struggle. That a broken plate and scuff marks show that Avery Becker attacked Mackenzie Brockman because she was unaware that he was home. And sadly, she had to commit murder because she did not know that a burglary would go wrong. The prosecution has shown with the evidence that Avery Becker is guilty of her crimes with first-degree murder and second-degree burglary. However, the defense wants you to see the whole truth and nothing but the truth. The only truth here is the prosecution's case. Let's go back and look at the defense's witnesses. First, you heard from Avery Becker, who testified on the stand that she had a conversation with her mother, saying because of her anger, she would get back at Mackenzie Brockman if it was the last thing she did, by breaking in and trashing his residence, as she said on her exhibit or on her text messages to her friend, Alex Cifuentes. You heard from Taylor Perkins that he quit the team for her, yet he's the only alibi for Avery. Avery and him never provided any physical evidence to you today to show that they were at the Fry Shack, to show that they were at the mall. They cannot prove where they were. And contrary to that, Exhibit 15 suggests that Avery Becker was at Mackenzie Brockman's residence from 1:05 p.m. to 1:17 p.m. at 444 South Flower Street. Then you heard from Van Owen, who attempted to uncover truth by refuting our theory of the case. However, you have seen that Professor Blake Van Owen is highly biased against experts from our side of the case, calling some of our witnesses egotistical. Yet, it's all because of the bias that they never got along and they are not a police officer and have been disconnected from the practices for 8 years now. I'd like to refer to jury instruction number 6, that just because someone is certified as an expert does not mean that they are credible. You do not have to believe a word they say. However, they are not credible. Today, as the prosecution, we bear the burden of proving to you beyond a reasonable doubt that Avery Becker is guilty of first-degree murder and second-degree burglary. And we have absolutely met that burden by showing you the whole truth and nothing but the truth. Avery Becker, with the intent to burglarize and vandalize Mackenzie Brockman's residence, was caught unaware that Mackenzie Brockman was home. And unfortunately, she had to commit murder. Ladies and gentlemen, do what is right. Do not let revenge go unpunished. Do not let revenge go unanswered. Do what is right and convict Avery Becker of first-degree murder and second-degree burglary. Thank you.
Thank you, Mr. Diamond. And now we'll proceed with closing argument from the defense.
Whenever I'm ready, Your Honor.
You may proceed. Thank you.
Your Honor, members of the jury and opposing counsel, the truth, the whole truth, and nothing but the truth is important in every case, but especially this one. And the truth is that the prosecution has not presented enough evidence that isn't riddled with doubt for that burden of proof to be met. Now, there is one instance where I agree with the prosecution and when they did tell the absolute truth, and that's when they say that they have the burden of proof in this case. Now, have they met that burden? Ladies and gentlemen of the jury, absolutely not. Before I continue, allow me to read you jury instruction number 2. It says, if you find, members of the jury, from the evidence that the prosecution has failed to prove any one or more elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. Members of the jury, all you need is one. What the defense has presented to you today on the side of the prosecution in examining all of their investigation has shown you that there are multiple examples of reasonable doubt that is present within the investigation on the side of the prosecution. Now, first, we have to talk about this spotty detective work on the side of the prosecution investigators. Kyle Kuzak is a person who really talks up his method of investigating and conducting research and analyzing things and witness tracking sheets. But when Taylor Perkins mentions Blair Rollins as a possible suspect, he's not followed up on. He is not actively pursued to a level that a suspect should be in a case. Members of the jury, there is a person out here that is a possible suspect in the murder of Mackenzie Brockman. Members of the jury, that's doubt. That's doubt. We also have to talk about the scuff marks, the smoking gun in in reference to the prosecution's case in regard to there being a struggle. But before I go into the scuff marks, let's talk about the struggle itself. The prosecution wants you, members of the jury, to believe that a girl in high school took down a grown man, Mackenzie Brackman, wrestled with him for the murder weapon, took possession of the murder weapon, and stabbed him in the back. Members of the jury, that's doubtful. And of course, the scuff marks in general, Kyle Cusack himself said that those scuff marks can't be carbon dated. We don't know when those scuff marks were created. They could have been created the day of the murder, or they could have been created 2 years prior. We don't know. Members of the jury, that's doubt. These text messages, another smoking gun in their case between allegedly Alex Cifuentes and Avery Becker, but this goes back into the spotty detective work. The phone was not taken into custody. Alex Cifuentes offered to give the phone to the investigators, but it was not taken into custody. Instead, they were presented these screenshots, which very well could have been doctored, screenshots that we don't really know the authenticity of. Members of the jury, there's doubt in regard to whether these screenshots accurately depict text messages between Avery Becker and Alex Cifuentes. Members of the jury, that's doubt. And of course, we have to talk about Taylor Perkins, someone who knows Avery Becker better than anyone else here. Taylor Perkins was with Avery Becker the entirety of March 6th, searching for a missing phone. Taylor Perkins was with Avery Becker. Avery Becker was with Taylor Perkins. There's no doubt, if you believe the testimony of Taylor Perkins, for that to be true. Members of the jury, the investigators in this case had a predetermined conclusion. They had the blinders up, and their only suspect that was pursued was Avery Becker. At best, they're incompetent. At worst, they neglected to follow up on other information because they knew that Avery Becker was the suspect that they wanted to charge with this crime. Members of the jury, Avery Becker was apologetic. Tears came out of Avery Becker's eyes in this court Zoom. She wishes she ended on better terms with Mackenzie Brackman, and it tears her apart that she was not able to. Members of the jury, there is one conclusion that you have to reach in this case. Not guilty, not guilty, not guilty. Thank you. And the defense rests.
Thank you, Mr. DeSalvo. I think there were 10 minutes or 10 seconds remaining for rebuttal. If the people wish to try and use that rebuttal for 10 seconds, you may. Mr. Dahman?
Yes, Your Honor. Members of the jury, I'd like you to refer to jury instruction number 3 that says that direct evidence and circumstantial evidence are in the same way. And all that circumstantial evidence points to Avery Becker beyond a reasonable doubt. Guilty.
Yeah. Thank you. All right. That completes the presentations of evidence. I'm going to pause here for just a minute to allow the scorers to complete their scorecard. Then we'll come back up. Everybody who wishes to can re-engage their camera. If you wish to re-engage your camera, you're welcome to do that. And I want, of course, the scorers to do that because I'll give you an opportunity here to address the panel as well. Bearing in mind, we're going to try and keep our marks to under a couple of minutes. Before we do that, let me just see by way of show of hand. Let me ask it this way: is there any scorer who needs any additional time to complete their scorecard? I'm not seeing that. All right, Mr. Downey, if you are there, I think it's at this point that we try and hit submit and hope the ship sails. So I'm about to do that. And any special instructions before we do that?
No, I just need to make sure that nobody leaves this meeting before they hit submit. I will tell you, Judge Schutz, I think your ship probably has already sunk before it sailed because I have not received a submission slip from any judge on the court computer system because there's an internal error that results. So you're probably going to need to either make a PDF of it and email it to me, or take a picture of it and text it or email it to my phone. So I can cover that with you later, but I will let you know. Wait a minute, I have some score sheets coming in now, so I can let those judges know that everything looks good. And
let me hold you for just a minute, Mr. Downey. So I have pressed the submit, and I have the same error code that I suspect you've already seen: error processing entry, internal server error. I will confess with a measure of great pride that I am one of the last human beings without a cell phone. So I do not have a smartphone by which I can to take a picture and send it to you. I can try in PDF. The other thing that I have the capacity to do, my camera is mobile, and I can literally turn the camera onto the bottom of the scorecard. If I do that, of course, I'm presuming everybody will be able to see that scoring, which doesn't bother me in the least. But the other thing I can try and do is I can try and PDF it and then email it to you.
Well, I can let you know I have score sheets from Ms. Brunner and from Mr. Straight. And why don't we let everybody leave this meeting, Judge Schutz, after it's over? Why don't you not leave, and then you and I will work out how I get that.
Very good. That makes sense to me. So I want to turn now to the individual panelists. I'll say more about this in just a minute, but let me, again, on behalf of the students, on behalf of all the participants, express my appreciation for those panelists who are willing to serve, give of their time to the community to serve. So thank you for being here. We'll start with Mr. Forster. Anything that you want to communicate to the group? First, tell us who you are and some context on what you're doing when you're not scoring mock trial, and then anything you want to communicate.
Great. Well, I was really impressed by the whole thing. Just briefly about me, I've spent a career in the Air Force, and I've got about 27 years teaching at graduate and undergraduate levels, which I do part-time in my quote semi-retirement, and a Rotarian. And so this is the second time I've been able to do this. And so that's my context. I'm not a lawyer. I was accused of thinking like one once, but that was by a good lawyer. So I took that as a compliment. I was really impressed by all of you. I just hit submit, so I hope, Jason, you got mine as well. And I will tell you that without saying who I ended up on, that the best attorney I was still scratching my head. All of you were really good. The witnesses, I thought, were just sterling. I thought Crystal's little tears at the end were effective. All of you, carried your stories well. Very, very good in using redirects and objections from the attorneys. And I thought the evidence came out clearly, and the arguments were very well made all the way around. So I think all of you should feel very proud. It was a very close run.
Thank you. I appreciate those comments, Mr. Forster. And next we'll go to Ms. Brunner.
Mr. Forster, I did receive your score sheet.
Good.
Thanks, Judge. So I'm a litigation attorney. I've been a litigation attorney for 15 years. The past 8 years, I've done litigation for the United States Forest Service. And I thought, again, I'll echo a lot of the same comments. You all did just a fantastic job. Very professional, really well done. Congratulations on finishing another round. You should be very proud of yourselves. I would also echo that the witnesses all did a really good job. I wrote down specifically Mr. Fish and Ms. Caruana. You both just were very believable witnesses, very natural. The opening statements were very good by both of you. Nicely done. And then Mr. Dahman, I thought your direct examination was very good. It was very natural. You've got a good tone and really good pacing. But everyone just really an exceptional job.
Thank you, Ms. Brunner. And Mr. Straight.
Yes, Judge. Thank you. I echo that. There's not much else I can add. That you've all done a really great job, and I appreciate all the time that y'all put into working on this. You've demonstrated that you think like lawyers, which is looking at your case that has holes in it and has glaring issues, and how you present the case, taking into account those issues, and how you put stuff out to try to cover the holes and put your best foot forward. So that's one of the things that this is about. Not only is the work ethic, but whether you can look at the case and figure out what the holes are, what the strong suit is, how you apply the rules of the evidence and the rules of the this process, and make a presentable case. So anyway, and just one example of really thinking great on your feet was when Brendan, I think it was Brendan, who pointed out on cross-examination that the witness had said that we react to things when we're angry. And so the attorney pointed out that, oh, does that mean that you may kill someone when you're angry? It's like, yeah, that was really well done. So sometimes lawyering is just thinking well on your feet and something just pops up. And that's about all I have to say about this. I appreciate you're letting me be a part of it. One thing that struck me is having Professor Van Owen go last was a witness that just really switched things around, and from there, from the defense, changed the perspective. It was kind of like John Grisham's novel Sycamore Row, where all of a sudden a witness came in at the end and made everything clear and made everything make sense. Oh, my background, if you're interested. I'm a recovering lawyer. I used to be a prosecutor and then worked in very civil practice and then did tax work. And since recovering from the profession, I've been teaching at the public school level and then at the collegiate level. So thank you again.
Thank you, Mr. Straight, I appreciate that. I'll try and be brief as well, but echo some of the comments and maybe offer a few big picture observations. I have been doing this for, I think, north of 20 years now. I have been on the bench as a district court judge, a trial court judge. This is my courtroom in which I'm sitting right now for a decade now. I've had a chance to see lots of mock trial competitions, and both at a college level and at a high school level, and of course the real deal in the courtroom in terms of disputes over the last decade. You all did great. Really, really enjoyable program. You all were clearly well prepared. The pandemic just has created enormous challenges in the process of presenting a case, and I thought you did exceptionally well in moving between the technology. You clearly are conversant on the rules of evidence. I liked the back and forth on the exchanges. Really good job in your preparation. A couple of things that I would offer by way of just brief suggestion. Really important, and I think now even more difficult, to try and communicate in a direct way. Mr. DeSalvo, on your closing argument, I thought you did that a good job of that. It's hard when you're talking to just a screen and not human beings to make that human connection. I thought you did a very good job of that. Try not to read responses and your presentations, and I thought that generally you did a good job in that. I would echo Mr. Straight's comment on listening to the answer and not just reading from the script. So sometimes you get an answer there that you can capitalize on, as Mr. Straight noted that Mr. Mayer did. Some question, there's an old adage among cross-examiners, sometimes you ask one too many questions. You could have maybe worded that question a little bit different when you didn't, and not give the defendant, or excuse me, the witness, I think it was Mr. Onwuka, the chance to kind of come back and argue with you about it. But you picked up on something that he gave you, which is really important in examinations. So not just tying yourself to the script, but listening and taking what information is being given and then using it. I want to make couple recognitions. I guess one thing before I get to broad recognitions, one of the great things about this year is that you're going to have video. You're going to be able to go back and take a look at it, and I suspect you've already been doing that in your initial rounds. That's great. Hopefully you'll be able to learn from it, and both in terms of this competition and going forward. A couple of things. I want to just simply recognize the coaches and the parents and all the volunteers. I hope that you appreciate what you heard there in terms of these are leading citizens in the community who are giving of their time on a Saturday morning to get up and come down here to preside over this, which I think is a testament both to the service nature of the Rotarians and to the service nature generally of the legal profession. And proud to be able to preside over that. And the parents, I know, make a big sacrifice, and I think nobody makes bigger sacrifices than the coaches in the mock trial competition. It just takes a long time and a lot of commitment, aside from the students. I'm talking about the volunteers here. This program means a lot to me because the first time that I ever wore a robe was serving as a judge in this program. I had actually judged maybe half a dozen years, and we didn't have enough actual judges to preside. So the first time I actually wore a robe, I was acting as a judge, sitting in another judge's actual courtroom. So near to me from that standpoint, and lots of other reasons. This is really a great program. It gives us an opportunity to see the system working and to make sure that generationally we are aware of the system and all the things that go with it. I hope that I have maybe some people who will repeat my sort of experience in playing a judge and then becoming a judge, in that you are playing lawyers in this role, but I hope some of you actually take up and one day join the bar as lawyers yourselves. During the pandemic, one of the casualties has been jury trials, so we just generally don't have jury trials. And I think that's too bad, because it is such a great opportunity for the community to observe trials and to know about our legal system and observe the legal system. When I speak to jurors who come in, I often remind them that what responsibility and privilege it is to serve as jurors, and remind them of the importance of the American legal system, and that we are the beneficiaries of a great system. And the notion of being tried by a member of your peers, the fact that we don't trust these huge decisions to individuals, to men or women in isolation, but to the community. And the jury system reflects that. And it also reflects the notion, as you are seeing here in your experience, of the rule of law and the importance of the rule of law. Again, we are the beneficiaries from the sacrifices made by generations of people that have allowed us to have the system that is the envy of the rest of the world, that is the American justice system. It requires good people like yourselves being educated about the system, protecting it, and making sure that we pass it on to the next generation intact. As I look at you, as I look at the participants here, that gives me a lot of faith in that notion that we will be able to pass it on to good hands, and that there will be good hands to carry it to the next generation thereafter. So thank you for all of your work. We really do enjoy the opportunity to watch your good work. You should be proud, all of you. I will share that I found this to be a very close and highly scored competition, which is a reflection of the good work of each of you individually. So congratulations for that, and thank you for allowing us to participate. I think at this point that we have everybody's time or scorecard submitted, and so with the exception of me. So I think if you could confirm that, Mr. Downey, and then what I will do is just simply invite you to close down your cameras, and I will stay on and not sign off so that I can figure out how to get my scorecard to Mr. Downey. Mr. Downey, you have everybody else's score?
I do.
All right. Thank you again. Our pleasure to preside over this, and wish you the best in your going forward. Nice job.
Thank you all for
All
your
right.
time and for judging our round.
Yes,
Thank you.
Thank you.
Good luck.
All right. So I'm not sure what makes the most sense for you, Jason. I'm perfectly comfortable with just turning the camera around. I'm perfectly comfortable reading the operative lines to you.
Okay.
I could try and PDF it, however you think is best.
Well, I'll let you do what you want. I can tell you Judge Kilgore had the same problem. She was able to somehow, I guess, maybe cut and paste it into a Word document and then email it to me. Judge Bentley yesterday saved it as a PDF and sent me a link, and I was able to get it. But I'm happy to, if you just want to tell me the numbers, I'll write them in. I think that
Bear with me 1 second. I'll see what I can do here in terms of, I don't have a save option for it. Let me see if I can. How are you surviving?
Okay. Just a couple glitches here and there, but yesterday was pretty high stress. I mean, when you have done this as long as I have, you know, you get into a routine, and it certainly was disrupted with with all of this technology.
I could believe it. It's not letting me cut and paste simply and not letting me PDF it. I think what I'll do is just give you the scores if you're comfortable with that.
I am comfortable with that. So let's start with the, I have all the names and everything else I need. Let's start with the plaintiff opening statement.
7.
Okay. And then do you just want to go down?
Sure.
Column? Okay. So let's just go down, and then the direct examination of by plaintiff's counsel 1, just read down.
9.
Okay.
And then 8.
Okay.
Then 8.